Mr. Chairman, we are live.
Excellent. Well, good morning, everyone. Welcome to our final meeting of the 65th Legislature for the Select Committee on Blockchain, Finance, Technology, and Digital Innovation Technology. We've got a good agenda today and then half day tomorrow, where we'll be finishing up some of our actions on autonomous vehicles, decentralized autonomous organizations, do some work on digital identity and data trusts. Hear from the University of Wyoming Division of Banking, where we've got some legislation. We'll look at finalizing action on disclosure of private cryptographic keys, discuss SIM card swaps this evening, and then tomorrow we've got a few presentations after discussing commercial filing system with the Secretary of State's office. Before we go any further, let's take roll. It looks like we've got most everyone here.
Senator Dockstader.
Here.
Senator Driscoll.
Excused.
Senator Nethercott.
Here.
Representative Greer.
Excused.
Representative Lindholm.
Here.
Representative Yin.
Here.
Mr. Kaufman.
Here.
Ms. Long.
Here.
Mr. Revelle.
I know he's here. I see him.
I see him as well. Co-Chairman Olson.
Here, and Representative Greer has arrived as well, so you can mark him here.
And Co-Chairman Rothfuss.
I am here. All right. Before we get started, Mr. Co-Chairman, comments?
Yeah, thank you, Mr. Co-Chairman. Just really excited to drive this to a close, or pretty darn close to a close. I think we've got some great legislation in front of us. I'm excited to have the discussion on it. Even more excited to watch some of this legislation move forward for Wyoming and for the industries involved. Mr. Co-Chairman, I did want to note that unfortunately I'm attending two legislative meetings today. I'm attending budget meetings as well, so I'll be bouncing back and forth between those two meetings, and just wanted to make sure all the members and folks out there watching understand that I'm trying to balance between two, but I'll be here when I can. So thank you, Mr. Co-Chairman. That's all I have. You're muted, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. And no problem with that. We'll certainly do our best to make sure that you have opportunity to get back over here for votes or anytime we need you to weigh in on policy issues. Mary Beth, please note Senator Driscoll is present. Welcome, Senator Driscoll. Good morning.
Thank you. Sorry about late. I had a little hard time digging you out of the calendar again. I don't know.
Not a problem. Okay, with that, before we get started, are there any further announcements? Committee, anything that we should touch on before we get to our first agenda item? Seeing none, first agenda item this morning is autonomous vehicles. Let's bring in General Luke Reiner with the Wyoming Department of Transportation and Jesse Kirkmeyer. We'll get an update from them, have an opportunity to listen to the progress that's taken place on the autonomous vehicles legislation that was sponsored by the Joint Transportation Committee, and understand maybe a few of the tweaks that went into that. Then we've got an opportunity for the committee to talk about it, as well as to consider and discuss a little bit of a project that's going on with autonomous vehicles and communications. So with that, General Reiner, welcome. The floor is yours.
Hey, thank you very much, Mr. Chairman, members of the committee. For the record, Luke Reiner, Director of WYDOT. Hey, listen, just a couple comments from me, and I'd like to kick it over to Jesse, just for him to Mr. Kirkmeyer, for him to do as you asked, Mr. Chairman, to talk about some of the amendments that were made. But let me just thank this committee for your efforts in this area. I do think it's important for us as a state, and certainly for a transportation community, to look ahead, to be proactive, to be aware of the issues that are coming at us, and to set the conditions for our success in these spaces. And this bill does that very nicely, and you have been instrumental in helping set those conditions. And I think the tweaks that the Joint Transportation Committee made helps us and furthers it along. So with that, Mr. Chairman, I'll ask Mr. Kirkmeyer to jump in and walk you through really the amendments that were made and some of the remaining friction points.
Excellent. Thank you, General Reiner. Appreciate that. Mr. Kirkmeyer.
Hey, thank you, Mr. Chairman, and good morning, and good morning to everyone. First, I'd like to thank both yourself and Co-Chairman Olson for being part of the process. I would also like to note that I am hosting an additional working group meeting tomorrow to cover this with the stakeholders, and I'd welcome any member here who would like to attend the meeting. Just let me know, and I will send you a calendar invite so you can attend it via Google Hangouts. Very quickly, just want to cover the 5 amendments and then 2 kind of wording adjustments LSO made, and then identify some possible remaining friction points with some of the folks that we had help us develop our final recommendations. So if you quickly want to go through the bill, sir, the first one to note, unless there are any questions.
No, please proceed.
Okay, the first one is at the request of a member of the JTC and recommendation of LSO in the definitions portion. LSO did add to the standing definition of what a automated driving system is. They added what they had from the old bill, which also included what it is not. That's not what was in the J3016 definition that we put in there, but it did clarify it for some members. The second change I'd like to note is in section 3121-103. Paragraph A, subparagraph I. They eliminated all the wording after the word laws. And this was a recommendation highlighted by one of the stakeholders. They just felt that the wording that was in there was unnecessary. And the members agreed to eliminate that wording. The third change is in paragraph 31 or section 3121-105 subparagraph C. And they removed the term data recorder, which caused some consternation with the industry reps. And after some advice from Colonel Haller of the Highway Patrol, he agreed that removing that word would be okay from their perspective, and also changed the word interact to obtain. And basically, they agreed to treat AVs like they do any other vehicle and do the legal process in order to get information from whatever is in the AV post-crash that might provide that information. And Colonel Haller was accepting of that change. They did make a slight adjustment to the wording where it noted the current section of 31-5109 was actually incorrect. It should have been 31-5108 in that same paragraph. And so they did make that change. The next change they made was in section 3121-108. They added subparagraph D, and this was to address some concern by the insurance industry about manufacturer liability, and it was set at $5 million. And the final change, this is probably the most contentious thing in the bill with some of the industry folks, is just the whole notion of putting testing in the bill. Again, we were directed to provide a holistic bill, everything from testing through deployment, through integration and effective use on safe use on the roadway system. So we added this section. In order to address their concern about testing, they added the words that do not meet other requirements in this article after the term ADS. And what that was meant to convey is that if a system that has not been fully licensed and credited, I guess, by the federal, by U.S. Department of Transportation, but they want to do a demonstration or a testing on Wyoming's roadways, then this would apply. Now, I frankly don't know if this will satisfy the industry folks that are concerned about this, but that was the JTC's attempt to address this concern. I would like to note that there are 2 issues that LSO really did for clarity. The first one is we dropped the definition of conventional driver from the original. That's because once we decided to convert to the June 2018 version of J3016. We no longer use the term conventional driver elsewhere in the bill. We only use human driver and dispatching entity. So it made sense to drop it from the bill. The second one was just a clarity thing. Originally in paragraph section 3121-105, paragraph A sub paragraph 3, it really kind of restated what was in the bill earlier. So LSO just kind of deleted that paragraph because it was covered in I and II. So that's really a synopsis of all the changes. Based upon what's happened, I think it will appeal to some stakeholders, but I mean, frankly, you'd have to ask them on whether they're completely satisfied or not. But what we plan to do is, if the bill is successful and it passes, we plan to begin working on rules and regulations. And I really want to keep the working group together because their input was invaluable in helping us get this so quickly. This went from 0 to light speed in just a matter of months. So I think they'll be very helpful in helping us write rules and regulations. Pending any questions, that's all I have for you, sir.
Excellent. Thank you, Mr. Kirkmeyer. Committee questions? Mr. Kirkmeyer, I have a couple quickly, and then we'll have an opportunity to get to public comment, I think, on this and see if there are any concerns that are raised. But in some feedback that I received, there was a little bit of a question about the addition of the manufacturer insurance requirement versus the vehicle insurance requirement, the driver insurance requirement, or the responsible operator. We don't really have a driver. The operator insurance, which are two different insurances, do we have an equivalent insurance for the vehicle manufacturer if it's not an autonomous vehicle in place in Wyoming statute?
Mr. Chairman, I believe we do. I am not the expert, and I will confirm that for you. But in the course of discussions, I believe that the recommendation, which was by an insurance industry stakeholder, was to equate it to what is currently in statute for manufacturers and set the amount at the same level. But I will confirm that and make sure that is correct, sir.
Great. Thank you, Mr. Kirkmeyer. And that was exactly my concern, is that it seems like there needs to be parity there. And if this is unique on the manufacturer liability insurance, then it would, I think, be worthy of discussion why it would deserve special attention when we already have what is effectively the equivalent of a requirement for liability insurance for the operator, which will basically be the owner or whatever responsible party is. Anything else on that committee before I go to the next question? I see actually Ms. Jarvis. I don't know if she has any comment available.
Mr. If I may,
Go ahead.
I just got a note. So the note that I got is from our expert, and what it says is out-of-state manufacturers do not have to file a bond, the dealers do.
Okay.
So I'll get everything clarified for you and get you an answer by the end of today.
That's great. Thank you. And again, Ms. Jarvis.
Thank you, Mr. Chairman. This section that was inserted doesn't at subsection D of 31-21-108 as created in the bill is somewhat modeled after the existing statutes 31-16-113, which is about the product liability responsibility for manufacturers and dealers. It's not exactly analogous, but it is modeled after that.
Okay, Ms. Jarvis, what would the differences be? And I guess what I would say is, why couldn't the previous statute simply apply instead of creating this new statute?
Mr. Chairman, it is, I believe, well, the committee's intent was to put a section into this bill. By the committee, I mean the Transportation, Highways, and Military Affairs Committee, was to put it into this bill that talked about obligations of manufacturers. And I believe perhaps they were anticipating that they might not go through a dealer as their delivery. And so the mechanism that is in 31-16-113, where a manufacturer has to file certain things with the department to show that it can meet its obligations, might not necessarily apply, because it says, before delivery to the dealer. And so this is just its own section, largely modeled after it. Now, as to whether it would just apply, I think it would if a vehicle went on that delivery system, most likely.
Ms. Jarvis, on that point, though, we had a piece of legislation a couple of years ago that addressed a certain electric vehicle manufacturer that wasn't going to use a franchise dealership model. Did we not take into consideration that change at that point in time? Is there nothing governing that? I mean, it seems curious to me to create a unique circumstance for an autonomous vehicle that doesn't exist equivalently for a traditional vehicle from a manufacturer liability standpoint. And so I'm just trying to figure out, either it should be consistent across the board. Well, I'll just say that probably should be consistent across the board. So I'm curious, how did we manage that for that electric vehicle manufacturer where we're doing direct sale allowance in the state of Wyoming?
Mr. Chairman, I believe it is in this, in or near this same section, but I need to look into that specifically and can respond back to the committee about what was added at that time and how it may apply differently than this subsection D.
Excellent.
I'd be happy to just send a message to the committee after.
That's perfect. Thank you so much, Ms. Jarvis. Appreciate it. Additional questions, committee? All right. Thank you, Ms. Jarvis. And that's all I had for questions.
Mr. Chairman, I'm sorry.
Yep. Go ahead, Representative Lindholm.
Yeah, thank you, Mr. Chairman. And I apologize for not digging into this. I know that, under Wyoming law, you have to have insurance if you're going to be a motorist going down the road. But do we have a requirement that you have to show that to the treasurer already for other vehicles? Would be my question.
Thank you, Representative Lindholm. Ms. Jarvis.
Mr. Chairman, Representative Lindholm, for the motorist, him or herself, yes, they show that to the treasurer when they obtain their registration. This, the focus is on the manufacturer. And so that's why they show it actually to the department, because they may or may not have any interaction with a county treasurer. And that was the mechanism, or the pathway that was in 31-16-113 in the statutes. That's why their interaction is with the treasurer, the county treasurer.
Thank you, Ms. Jarvis. Follow up
is with the department. I apologize.
No worries. Follow up, Representative Lindholm.
Yeah, thank you, Mr. Chairman. Mr. Chairman, because this is being sponsored by the Transportation Committee, I mean, we're just doing a cursory look at this, correct? We can't amend it.
Representative Lindholm, we can if we want to sponsor a separate version of the bill. I was not necessarily inclined to do that since it's already going to work through the process unless we have major revision. So that it's up to the committee, really. If you've got big changes in mind, Representative Lindholm, then we can we can run our own bill.
Mr. Chairman, my only suggestion, and I don't suspect I would receive a lot of support, would be to strike a lot of this language.
Okay, thank you, Representative Lindholm. Any additional questions? All right, so that it brings up a good point that Transportation Committee did pass this, and they passed it in a form which is, I think, very similar to what we intended to see, where there was a good timeline. It made sure that we were forward-looking and leader with regard to the legislation. I think there, from my understanding, still are some potential points of contention, as Mr. Kirkmeyer pointed out, that will still be worked on, but we can probably work that through the process. So if there are no further questions on this, my intent is to go to the brief Tri-Hydro presentation, where they're going to talk to us a little bit about an autonomous vehicle and communications project that they have, to give us a quick overview, and then we'll go to public comment. Anything before we do that? All right, seeing none, let's go to that Tri-Hydro presentation. I see Mr. Garcia here on behalf of Tri-Hydro. Mr. Garcia, do you have a PowerPoint or anything that you want to walk us through, or because we'll need to screen share with you on that one?
We do, and I think Shane is actually on the call as well, where he's actually going to control the PowerPoint.
Perfect. Okay, the floor is yours.
All right, I gotta try to make sure I see you all. All right, thank you very much, Chairman Rothfuss, Chairman Olson. Good morning, and thank you for inviting Shane, Zumpf, and me to speak before the committee. Again, my name is Vince Garcia, and I lead the team at YDOT. I'm actually a YDOT employee, and I'm responsible for the connected vehicle pilot project. You've heard quite a bit about the autonomous vehicles, which have a full complement of sensors to try to navigate the roadways without driver input. I'm here to talk with Shane from Tri-Hydro about the connected vehicle project that we've been working on. A connected vehicle is one that has a special radio on board that allows it to communicate with other similarly equipped vehicles and with systems located at the roadside. When you combine autonomous and connected technologies, the transportation industry really has the best opportunity to reduce the number of crashes, injuries, and fatalities on the nation's roadway network. So I'm going to, let me start off by telling you that in March of 2015, the United States Department of Transportation issued a broad agency announcement that solicited projects to take connected vehicle technology that had been developed and mostly used in test environments to real world deployments. We pitched a project, and from about 40 proposals, we were selected along with New York City and a public-private partnership that's located in Tampa. I'm going to give you kind of some of the background information on the project, and then Shane Zumpf from Tri-Hydro, as a technical lead of our project, he's going to talk to you about some of the applications we developed, the safety benefits, and the very big roadblock that has recently been put in front of us. So with that, Shane, if you could advance the slide, please. To begin, I really want to stress that this project has been a significant effort from many programs at YDOT, and my team would not have been successful without this joint effort. Yes, we kind of lead the project, but there were many people involved. Next slide, Shane. And the head of the United States Department of Transportation, who's in charge of the connected vehicles, has stated many times that our project is really the best one they've seen. We did this by building a Wyoming-based technology group. When we put together our proposal, we reached out to the University of Wyoming to kind of provide the ethical oversight in the form of an internal review board. Also, they're working on the training module, performance measures, and then the simulation testing that's necessary to make sure we don't introduce some sort of a technology that causes additional driver distraction. We also reached out to Tri-Hydro to act as a technical lead of our project. We had worked with them before, and they've done an outstanding job, and I think the state of Wyoming should be very proud of the technical expertise within the state of Wyoming. Next slide, please. So let's kind of jump right into this. The project that we selected is to demonstrate the technology is located on the 402 miles of Interstate 80 in southern Wyoming. Shane, if you need to advance to slide one. As you know, this route is a major freight corridor. It delivers about 32 million tons of freight each year. The traffic stream is pretty steady at about 50% truck traffic, with lower percentages around towns along the corridor where passenger vehicles frequently jump on the interstate for short trips. But on a bad weather day, where passenger vehicles can often elect to forego a trip or maybe delay it or advance it, commercial drivers have a business reason to keep moving, and the traffic stream can be as much as 70% truck traffic. That presents problems with our weather. Next slide, please. You know that we have serious challenges in Wyoming. This graphic really kind of puts an exclamation mark on it. Yes, we get our share of snow and bad weather days, but this slide actually depicts the number of annual hours of blowing snow across the United States. And as you can see, there's really no place like Wyoming in terms of what we consider whiteout and blizzard conditions, blinding snow conditions. Coupling that with a lot of freight traffic, and you have a really serious situation. Next slides, please. And this is the kind of the result. We see a lot of multi-vehicle crashes that are all too common on Interstate 80. You've all heard about them. The one you're seeing happened actually on April 15th of 2015. This was located between Cheyenne and Laramie, where a really quick snow squall moved in, and it crashed out both sides of the interstate. The interstate was closed for about 3 days, and that was necessary to conduct the crash investigation as well as to get these vehicles towed away from the site. I'll point out just real quickly that our Transportation Management Center did see this snow squall on their radar and the many systems that they have. They were able to reduce the speeds in this area using the variable speed limit systems down to 45 miles per hour. And you've probably all seen the crash video of this. There were no fatalities in this crash. Next slide, please. 5 days later, in a different location, April 20th, 2015, this one located between Laramie and Rollins and about 1 mile away from a variable speed limit zone. We were not so lucky. 2 people did perish in this crash. They came in at a full 75 miles per hour. And again, the road was closed for about 3 more days as the crash site was investigated and cleaned up. These crashes happen every year. And if I remember correctly, I think we had 3 separate, and in one event we had like 3 crashes, but I believe there were 3 days last winter season where we had multi-vehicle crashes on Interstate 80. Next slide, please. And as a result, Shane, if you'd play this video, please. As a result of the winds, we see another type of crash all too often. The patrol vehicle you're focusing on was stopped and in frame of a dash cam of another patrol vehicle while the 2 troopers were investigating a blown over vehicle. And that's the result. The trooper was not in the vehicle at the time of this crash, but another trooper about 2 weeks before this event experienced a very similar event. And he was in the vehicle at the time. He did suffer minor injuries, was treated and released at the hospital. And I believe I'm correct in saying that Wyoming has the top 3 blowover locations in the country, according to the insurance industry. Next slide, please. So before Shane talks to you about some of the connected vehicle technology, I really want to stress that we haven't been sitting on our hands. We've been doing quite a bit. We've deployed a lot of technology on Interstate 80 in an effort to make the roads more safe. We pioneered variable speed limits. You're seeing these pop up all over the country at this point. We have about 160 signs in 4 different locations along Interstate 80, covering about 35% of the interstate. These are supported by 95 traffic sensors. We've deployed 42 electronic message boards to try to get information at the roadside to people. We have 44 weather stations and 54 web cameras to help people be better prepared for the environment. Next slide, please. And this is all based on kind of the philosophy at WYDOT that everything starts with good roadway design. You can see that we face some unique challenges on Interstate 80 that are almost insurmountable, but our roadway designers are really expert at using technology to develop and model the environment. When an alignment presents challenges like I-80 that just can't be overcome, you'll see a lot of effort to mitigate. They'll do that through things like slope modifications and snow fence. And I think Interstate 80, I'm pretty comfortable in saying it has more snow fence than anywhere else in the world. And finally, when those type of measures don't take hold, my group gets involved with kind of a technical solution. And with that, I'm going to turn it over to Shane. He's going to talk to you about our connected vehicle pilot project.
Thanks. Go ahead, Shane.
Thank you, Mr. Chairman. Thank you, Mr. Garcia. So for the connected vehicle pilot, as Mr. Garcia mentioned, we have 3 different pilot projects that were chosen: Wyoming, New York City, and Tampa. I want to go first off and explain a little bit about what a connected vehicle is and how it differs from an autonomous vehicle. So a connected vehicle you can think of as being able to broadcast its location, its heading, its direction, a lot of information about that vehicle itself, the size, length, etc. That information gets broadcast at 10 hertz from all of our connected vehicles. And all the connected vehicles can also receive messages from those same vehicles. This is all done over something called dedicated short-range communication radios. So we have different types of communication that occur from vehicle to vehicle, as well as from vehicle to infrastructure. Infrastructure radios that are installed along the roadside also can send messages to vehicles out on our roads. So a connected vehicle now is able to receive and send messages, but it doesn't actually control any of the functions of the vehicle itself. There is a tablet or some sort of device within the vehicle itself that communicates different information to the driver. You can almost think of it as like a traveling dynamic message sign. But it also has the ability to be able to tell driver of certain critical warnings where they need to take evasive action quickly. So I'm going to go over those different applications here in a second. But first off, I wanted to go over the different vehicles that we are currently outfitting with the connected vehicle technology. So all of the YDOT snowplows and highway patrol vehicles that are going to be along the Interstate 80 corridor are being outfitted with this connected vehicle technology. We also have engaged with a lot of private fleet vehicles, including commercial vehicles mostly, but we also have some other vehicles like Tri-Hydro's fleet that's also out on the I-80 corridor. So we're trying to outfit up to about 400, a little over 400 vehicles, be able to get as high a density out on there on the I-80 corridor as possible. So what do the different applications do? What is it about connected vehicles that is going to help Wyoming out? Well, for the first application that we came about was a forward collision warning. So as I mentioned before, all of the connected vehicles are broadcasting information about their speed, heading, location. And we have run into a scenario where we have a snowplow that might be kicking up a ton of snow, and it's also slow moving, removing snow off of I-80. We also have a commercial vehicle that might be coming up onto this snowplow at a high rate of speed. Well, as those two get closer together, we can notify the driver of the commercial vehicle that they're about to have a collision with the snowplow in front of them, and that usually happens within 3 seconds. So we give them a 3-second warning to be able to hit the brakes or take evasive action in order to avoid that collision. The next application that I'm going to talk about is called the distress notification. This application is unique to the Wyoming pilot project and is actually something that Mr. Garcia, along with some other YDOT staff, came up with that they thought was a huge need for Wyoming. So we have a vehicle in this scenario that is able to push a button on their tablet within the vehicle itself to show that that vehicle is now in distress. So either that vehicle had gotten into an accident or it's run off the road or something to that effect. That vehicle then starts broadcasting a distress notification. Other vehicles on the opposite travel bound are then able to receive this message from the distressed vehicle, and they get notified that there's a distressed vehicle ahead. As that vehicle then travels down the roadway, it starts rebroadcasting that same message to other vehicles. Other connected vehicles then pick up that message and can notify the driver that there is a distressed vehicle ahead. This allows them to be able to slow down and make sure that they avoid anything from the distressed vehicle ahead. That second vehicle then can actually communicate with a roadside unit, so that that radio that's installed along the roadside to be able to broadcast that same message, that same distress notification out to the roadside unit. And then that can actually be broadcast back to the Traffic Management Center. Traffic Management Center then can deploy emergency services to that distressed vehicle's location. So that's the distress notification application. And the final application I want to go over really quick is the I2V situational awareness. Again, all of the connected vehicles that we have outfitted here, you can really consider the tablet or the touchscreen monitor that's installed in these vehicles as traveling dynamic message signs. So those dynamic message signs that are deployed along the interstates, everybody's aware of now, that communicate valuable information to drivers, we can now communicate to drivers along all of I-80. This is done through roadside units, so those infrastructure radios that are installed along the roadside. And in addition to that, WYDOT also partnered with SiriusXM to be able to deliver these same messages over satellite. So now with that satellite capability, you're able to actually expand the area beyond just I-80 to all of Wyoming. So as vehicles, snow plows and whatnot, transmit information back to our traffic management center about road conditions, road work, or even parking information, that same information is then broadcast out to all of our connected vehicles, and those connected vehicles then are able to receive road condition information as they are coming up on bad road conditions. So Mr. Garcia, mentioned that there was sort of a hiccup thrown up in our pilot project. This is what it was, where the dedicated short-range communication radios that we've deployed are in the 5.9 gigahertz band. Now that 5.9 gigahertz band was proposed to be reallocated at about November of 2019. And that passed through, and the proposal there was to reallocate the spectrum of that 5.9 gigahertz from DSRC to unlicensed Wi-Fi, and a smaller portion of it would still be allocated to the safety spectrum for transportation, and it would be renamed to C-V2X, or Cellular Vehicle to Everything. Just recently on November 18th, just a month ago or so, the FCC unanimously voted to reallocate that spectrum from DSRC to C-V2X and unlicensed Wi-Fi. This is actually a headline from Car and Driver, and it speaks volumes there, where there has been decades of research that was spent on DSRC technology, and now it's being replaced with C-V2X. So the majority of the spectrum did move to unlicensed Wi-Fi, and it does lessen the promise of connected and autonomous vehicles. There's just a smaller band of radio that we can actually use now for these safety of life applications. So I also wanted to touch on some of the many benefits for the connected vehicle pilot. In particular, what WYDOT has done in order to be able to integrate with connected vehicle technology. All of our backend systems have now been fully integrated into the traffic management center. This did not require any new traffic management center operators. Mr. Garcia was adamant about that we would not be able to increase the number of people in our traffic management center operations. We are leading the world in rural CV technology. So WYDOT is in the forefront here. We also have an amplified benefit for autonomous vehicles. And if you look at this with an autonomous vehicle traveling on I-80, and you saw all of that blowover in particular, a camera and with computer vision for autonomous vehicles, it's not going to be able to detect wind. And getting extraneous information from infrastructure to be able to notify them that there are no high-profile light vehicles that are allowed through this section is going to be critical. So this extra information going to autonomous vehicles will help them be able to make intelligent decisions on whether or not they can travel. It also has a lot of safety and mobility benefits where drivers can be able to make intelligent choices based on more information that's given to them. But really the bottom line is that safety and transportation system reliability leads to social and economic benefits. So what's the future of the Y.CB project based on the FCC ruling and everything? Well, Y.dot really does have a resilient design. All of the RSUs and the OBUs purchased have that dual satellite DSRC capability. So as we're told to turn off the DSRC, we still have the ability to deliver those same messages over satellite. All of the infrastructure to vehicle information, again, can be delivered through multiple sources. And we are looking to also expand that to 5G or 4G as well. We're also looking at expanded technical capability to deliver traveler information messages statewide. We've already done that. We've built that into the Y.dot Traffic Management Center. We're also continuing to deploy Y.dot and fleet vehicles for the pilot project. It was kind of exciting. Yesterday, we actually started our first commercial fleet deployment. With that, Mr. Chairman, thank you very much again for having us, and we can answer any questions you may have.
Thank you both. We appreciate the testimony and the presentation. This is a neat project, and it shows, I think, some of the work that we can be doing as we improve autonomous vehicles and integrate with this connected vehicle concept in the state of Wyoming. And it's great to see that we're a leader in this area. Questions for Mr. Zumpf or Mr. Garcia? Any questions? Okay. Well, appreciate the update. Go ahead, General Reiner.
Mr. Chairman, just maybe a quick comment, not a question. I'd just like to chime in and say I'm just really proud of this team. They've done exceptionally well and really stayed focused on safety. The thing about those pileups is it's a slow crash, and it's not seconds, it's minutes, or a half an hour. And you watch those videos of trucks and cars running into the back of each other, and really lives being lost. It is just, to me, we've got to stay focused on this connected vehicle and as it relates to autonomous. But I'm a fan of this connected vehicle technology. There's some pressure that we turn off the test when this DSRC spectrum issue came up, and we basically said no. This thing is critical to the safety of our roads, and we're going to keep rolling because we think it's key to the future of safety, not only in Wyoming, but across this nation. This DSRC thing is a huge issue. We've worked it all the way up through Congress. It's not, I don't see it changing at this point. So we're going to have to figure out a way ahead under the new rule set. But I just wanted to publicly thank, Mr. Zumpf, Mr. Garcia for their focused efforts and share with you that, hey, our intent is to stay in this space and be aggressive in this space because we think it makes a difference. And so, Mr. Chairman, thanks for that opportunity to comment.
Excellent. Thank you, General Reiner. Appreciate that. Any questions for General Reiner? All right, seeing none, thank you all. Thank you for the presentation. We look forward to updates on this and integrating this with our autonomous vehicle policy as we move forward. I think that the two technologies go well together and are critical to go hand in hand. With that, unless there's any comments or questions by the committee, I see none. Let's go to public comment on autonomous vehicles, as well as the Tri-Hydro Connected Vehicle Project as we see fit. I see Mr. Nathan Anderson. So let's start with Mr. Anderson. The floor is
Thank-
yours. Please
thank you,
introduce yourself to the committee, and let's try and keep testimony a little bit short, down to around 5 minutes with some time for questions. Thank you.
Thank you, Mr. Chairman. My name is Nathan Anderson. I represent Union Pacific Railroad, and I will do my level best to keep this well under 5 minutes. I want to commend the innovation and technology integration we've heard about today. It's exciting, and I very much appreciate the focus on safety. Union Pacific's #1 priority is safety, and as autonomous vehicle technology advances, and as we look to fully develop and deploy level 3, 4, and 5 technology, we want to make sure that public safety at rail crossings where existing roads cross the railroad tracks is uncompromised. And to that end, I guess my point of my comment today would be to highlight the importance of state and railroads working together if legislation will change the rules of the road where roads cross the rail. We look forward to working with members to address any potential safety concerns as bills move forward and as different bills, as were mentioned today, address the proposals for autonomous vehicles. Thank you.
Excellent. Thank you, Mr. Anderson. Appreciate those comments and making sure that we're integrating the rails with the roads. Any questions for Mr. Anderson? Seeing none, thank you, Mr. Anderson. Appreciate your testimony.
Thank you, Mr. Chairman.
All right. I see Ms. Wilkinson. Let's go to Ms. Wilkinson next.
Good morning, Mr. Chairman, members of the committee. Catherine Wilkinson, representing American Property and Casualty Insurance Association. Mr. Chairman, just very briefly here to stand in support of the bill, along with the amended liability insurance, the 2 separate ones. The $5 million really is intended for the testing. We understand that is more of an industry standard, although some states do bonding as well. So we would request that that be left in the bill, Mr. Chairman, and I would stand for any questions.
Excellent. Any questions for Ms. Wilkinson? Ms. Wilkinson, I don't anticipate we'll be amending or passing the bill, but I would ask, I'm a little concerned, and so when we actually get this to the legislature, I am concerned with different approaches to it and inconsistency in statute between specifically the automotive manufacturer liability insurance at $5 million. And I'm not saying there shouldn't be insurance or bonding or something along those lines. I get that, it makes sense, but I'd like to explore consistency and try and figure out a way where it meshes better with the other things we do in statute, if that makes sense. So if you could just sort of start looking into that, working with your folks and figuring out if there's a better way to do it, I think that would be handy. Thank you, Ms. Wilkinson. Any further questions for Ms. Wilkinson? All right, seeing none, thank you so much. Appreciate your testimony. All right, up next, Mr. Fisher, please introduce yourself and the floor is yours.
Yeah, thank you, Mr. Chairman. My name is Josh Fisher. I'm the Director of State Affairs for the Alliance for Automotive Innovation. We represent vehicle manufacturers, and they produce about 99% of all the light-duty vehicles sold in the United States. And we also represent several technology companies involved in the development of AV technology. Now, we appreciate the dialogue we've had with WYDOT staff and their willingness to listen to our concerns. We support most of the bill. We just want to highlight a couple concerns we have today and would look to some future amendments and have some language that we can provide in the future. The first issue I want to address is section 31-12-105 sub C, which relates to accessing vehicle data. This section would require that following a crash or traffic violation, the information from an AV must be accessible to law enforcement if it could be obtained from a human driver of a conventional vehicle. We think this subsection should be struck. We think it's duplicative and not needed. Section A already requires that a vehicle owner or person acting on behalf of the owner must report the crash and provide any information required by law. Also, EDR or quote unquote black box data is owned by the vehicle owner according to the Driver Privacy Act of 2015. So typically following a crash, law enforcement must work with the driver to obtain that data. And this same process should apply to AVs. Mr. Chairman, I think you made a comment earlier about keeping the current laws for conventional vehicles the same or as similar to automated vehicles. And we think this is an example of that. There's already a process in place to obtain vehicle data, and that same process should apply to AVs. With that said, we're definitely committed to working with law enforcement to address these issues moving forward. And the second section I want to highlight is the testing provision. This bill creates a procedure for DOT to issue temporary operating permits, but it doesn't really specify anything about that process, and the application criteria is left to be determined by the department. And we think that if you're going to set up a testing program, it should be structured more as a notification approach, similar to what Oregon's done. This approach eliminates delays in deploying test vehicles in Wyoming and creates a clear pathway to commercial deployment. So those are the two issues I wanted to highlight today, and happy to answer any questions or provide any follow-up information. And thanks for your time.
Thank you, Mr. Fisher. Questions for Mr. Fisher? Any questions? I'm curious with regard to the first concern relating to this paragraph C on page 12. What have other states done? What do you see as the best practice? Obviously, there are going to be circumstances where law enforcement does need to get information that is available that's going to be useful. What process do you consider to be the gold standard for that perhaps another state has adopted for similar circumstances?
Well, I think the process for conventional vehicles as it is now, if law enforcement, they can either work with the driver, or if there's additional information that is needed, they can issue a subpoena or a warrant to obtain that information. And so we think that same process should apply to automated vehicles. And that's what we've seen some other states do. You know, we just want these vehicles to be treated as similar or the same as conventional vehicles.
Excellent. All right. Thank you. That helps to clarify. So standard process and no special provisions. Okay. Is there anything when you contemplate black boxes and similar devices, does anything stand out, or is that typically through subpoena or warrant as well to get the information of a black box?
That's the typical process. Again, it's owned by the vehicle owner. So if the vehicle owner wants to cooperate with law enforcement, that's one way. And if additional measures are needed from law enforcement, that's the typical process.
I understand. Okay. Thank you. Any further questions? Go ahead, Senator Nethercott.
Thank you, Mr. Chairman. Just a question. Understanding that the technology would be similar to a cell phone location data information to law enforcement, is there a precedent in the industry to allow for kind of emergency exemptions or exceptions associated with law enforcement being able to access that location data?
Yeah,
Mr. Fisher.
Yeah, thank you, Mr. Chairman. Senator, I'm not aware of special exemptions. I think the standard practice is that our members are committed to working with law enforcement to address those situations as they arise. If there are practices outside of the norm, I'm not really aware of them. I think it's just the typical process. One aspect of this you might be getting at is that these vehicles can alert law enforcement to a crash through their telematics systems. But that's not necessarily accessing the vehicle data, correct? And so when we talk about vehicle data, there's so many different types, right? And this section doesn't really clarify what types would be accessible. It basically says all types are accessible by law enforcement without going through the typical procedures. And the industry has adopted privacy principles where we are committed to not just handing over all consumer information, but we are committed to working with law enforcement to address those extraordinary situations. And we think that the typical subpoena or warrant process is part of that, but also just communication between the industry and law enforcement can help establish those procedures.
Thank you, Mr. Fisher. And will you make sure that we do get written suggestions of this as well? I think we already have some of these points, but as we move forward, as this goes through the process, let's make sure that we continue to contemplate these. Any other further questions? Senator Nethercott, did you have follow up? Good. Okay. Further questions for Mr. Fisher? Seeing none. Thank you, Mr. Fisher. Appreciate your testimony.
Thank you.
All right. And let's see. Do we have Mr. Wolf? We do have Mr. Wolf. Excellent. Okay. Mr. Wolf, please introduce yourself to the committee, and the floor is yours.
Happy to do so. Thank you, Mr. Chairman and members of the committee. It's good to be back. I think I presented a couple months ago. As a reminder, Ariel Wolf, Counsel to the Self-Driving Coalition for Safer Streets. It's a group of the leading autonomous vehicle companies. 10 of them, it includes manufacturers, vehicle manufacturers, technology companies, rideshare companies, all together advancing the objective of bringing forth the benefits of autonomous vehicle technology, fully self-driving technology, as safely and swiftly as possible. So I won't repeat some of the comments that are made. I'll just associate the coalition with a number of the comments made, in particular on the manufacturing liability provision. I think what I would say there is the coalition supports in this context treating AVs and conventional vehicles in the same way. And so that may be in further examination of Wyoming law. I would just note that at a certain point in the process, my recollection, the draft legislation did include, with respect to operator insurance requirements, a reference to existing law, which is what the coalition would support, but did move to $1 million. So in section 104, it already has a disparate treatment with respect to liability, as I understand, by imposing a $1 million insurance requirement there. So on the manufacturer side, we would just ask that together it would revert to treating AVs and motor vehicles in the same way, conventional vehicles. Secondly, we make a small recommendation that with respect to regulations in section 111, that rather than a mandatory rulemaking, that there's a permissive rulemaking, just so that the legislation can take effect more quickly if under the parameters are set forth in the law, and that as the Department of Transportation, State Department of Transportation determines that there's needed to be some form of rulemaking, whether it's respect the process or otherwise, that can proceed in parallel. And then finally, one issue that it has not come up is that we understand that existing Wyoming law has vehicle equipment requirements that could inadvertently preclude fully driverless vehicles from operating in Wyoming. And so we propose that section, this is, would be in 102. And by way of example, and we can provide further information on this, there are equipment requirements. I'm just going to pull it up, bear with me for just 1 second. With respect to windshield wipers and mirrors that are in Wyoming vehicle code. And as on the federal side, certain autonomous vehicles and fully driverless vehicles receive exemptions from those requirements or related requirements, it may be the case, and this may arise in a delivery context or occupantless context initially, although it may proceed beyond that, that then while on the federal requirements they're exempted, they look at Wyoming code and those vehicles which are designed without those features because they don't need them in any way. They're human equipment requirements. That they then are still unable to deploy those vehicles on the Wyoming roads because of the Wyoming code. So we propose some language and happy to engage further with the committee to try and address that issue that is emerging on the horizon. With that, thank you so much.
Thank you, Mr. Wolf. Representative Yin.
Thank you, Mr. Chairman. Mr. Wolf, I was curious to know whether or not that issue has been brought up with the Joint Transportation Committee and what their thoughts on it were. Because I mean, I think it does make sense, but I'd love to hear what the other committee thought about that.
Mr. Wolf, go ahead.
Thank you so much, Mr. Chairman. Representative, we did raise this in the process, and I think it's a complex issue that requires further engagement. So it was raised during the process. I think we couldn't quite get to a point where the language would make sense, and I think the committee opted to move forward for the time being, continuing to look into this. But again, happy to continue to engage and find a path forward so that I think on all accounts, there's a desire to, if legislation is going to advance and be enacted, that it's holistic and is able to accommodate all aspects, and there's no requirement going forward to then go back and amend it to deal with an issue like this.
Thank you, Mr. Wolf. Follow-up, Representative Yin? Good, okay. Additional discussion or questions for Mr. Wolf? Go ahead, Ms. Jarvis.
Mr. Chairman, I just wanted to state that in section 31-21-104 as created by the bill, which talks about the insurance for the person who is dispatching the vehicle, or the owner, the section in a previous version that had been referred to was is one and the same as what is created here. It was just a little bit confusing by referring it in amount. It had said in amount specified in some other section, and then that is just verbatim put here. So that wasn't actually changed. It was as far as the amounts or the requirements. It was just listed out on what you now see on page 11 instead of referring to another section of the law statutes.
Thank you, Ms. Jarvis. Any questions for Ms. Jarvis on that? Appreciate the clarification. Okay, seeing none. Thank you, Ms. Jarvis. Further questions for Mr. Wolf? Thank you, Mr. Wolf. And I think that we definitely do want to, in this bill, as it works through the process, address these required equipment concepts and find a solution, some type of compromise that makes that work. If you don't need windshield wipers, don't have windshield wipers. I think we can probably all agree on that, but make sure that we get that right so that we don't end up reducing safety and having some type of unintended consequences as a result of it. So there's some work there, but I appreciate those comments. Okay, any further questions for Mr. Wolf? Seeing none, thank you, Mr. Wolf. Appreciate your testimony, your time this morning. All right, Mary Beth, that is the extent of the list of public comment that I have. Do we have anyone else?
Mr. Chairman, I do not have anyone else on my list.
All right, great. Thank you so much. Committee, discussion on autonomous vehicles. Any thoughts, any requests for follow-up, any requests for action? All right, seeing none, committee, I think what we'll do on this, I think the bill seems like it's in good shape, as we talked about before. I think we just need to stay engaged in the process as it moves forward, address some of the concerns that we've heard, make sure those get addressed, and continue to monitor it from the capacity of the select committee. But I think it's in good shape to move forward and continue to support the transportation committee's work. All right. With that, let's move on to our next topic. A little bit behind, but we'll catch up. Decentralized autonomous organizations. We've got a working group update to begin with. Let me get to the agenda here. I know there's been an upgraded draft that everybody should have available. We'll get to that in a little bit. We've got some of our experts that have been on the working group to weigh in and talk a little bit about what they've found and done. But I'll start off with Mr. Wright, perhaps, to give an overview of some of what we've been doing, and Mr. Kaufman to join him and weigh in and let us know how we've proceeded since the last draft that we saw earlier and what actions have been taken. But we will have an opportunity to walk through those changes in the draft with staff in a moment, and then we can reflect back on them. With that, welcome, Mr. Wright. Good to see you again. The floor is yours, but please take an opportunity to introduce yourself once again to the committee and to those folks watching at home. You are on mute still, Mr.
I was
Wright.
on mute. Thank you so much, Co-Chairman Rothfuss. Thank you to all the other members of the committee. It's really an honor, again, to be able to provide testimony. By way of overview, I'm a professor at Cardozo Law School in New York and director of Cardozo's blockchain project. Over the past several months, we've been working on a draft bill that would create a supplement to the Wyoming LLC Act, so it wouldn't change in any substantive way the wonderful, iconic Wyoming LLC Act. Instead, it would serve as a supplement, which would enable individuals, entities, or other interested parties to set up a type of an LLC referred to as a DAO or a LAO in Wyoming if certain requirements were met under the proposed bill. What we did in and discussed during previous committee meetings was create a supplement. The supplement at a high level enables the creation of a DAO or LAO organized under the Wyoming Limited Liability Company Act. It requires that there is a notice of restrictions and duties and transfers if somebody organizes a decentralized autonomous organization, so the public's on notice of it. It articulates the requirements for formation, which would require filing an articles of organization. It would require identifying the underlying smart contracts or software that's being used to manage the organization. It would accommodate both member managed DAOs or DAOs that are democratically managed by their members, along with algorithmically managed DAOs, which would be primarily managed via an algorithmic system like a smart contract. It articulates that the articles of organization will be publicly available, identify the smart contracts, and also can include other provisions that would identify to the public and to members how the DAO will operate. We think that that's a benefit so that the public can understand if they're interacting with these organizations, what they're walking into, what rights, voting rights, how interests may be accounted for, transferred, withdrawal or dissociation processes, et cetera. We've also made clear that at least by default, although it can be varied either in the articles of organization or the operating agreement, that fiduciary duties will be limited to the extent permitted already under Wyoming law, and obviously subject to the implied contractual covenant of good faith and fair dealing. And then we just handled a whole bunch of other issues, which I'm happy to go through in more detail. Since that last meeting, we heard the feedback from both members of the committee, along with some other feedback that was received from the public, and did our best to accommodate that. The feedback largely fell into a couple buckets. One question related to algorithmic DAOs and whether or not they created an issue. How would that work under Wyoming law? To address that concern, we included a couple new provisions in the draft bill. One is that if somebody's organizing an entirely algorithmically managed decentralized organization, it may only be formed if the underlying smart contracts are able to be updated, modified, or otherwise changed. We think that kind of threads the needle, whereby if there is something that's a concern, the developers themselves will have the ability to change that so that it doesn't harm the public. In addition, as a failsafe, we also included a provision that would authorize the Secretary of State, and or its designee to basically dissolve the DAO. So even though it may exist on a blockchain, it wouldn't be legally recognized in the state of Wyoming, and folks that are considered members would not receive the protection from the state. So we think that addresses that concern. In addition, we incorporated additional feedback that we received from Matt and some other folks dealing with dissociation and just some of the logistical issues of what it means to be a member, what it means to no longer be a member, and under what conditions that applies. We also did our best in the latest draft, which we just circulated, and hopefully you got the right version, because I mistakenly sent out a version that had some typos and some track changes. But we also tried to address some of the feedback and comments that we received from David and other members of the LSO office. So what we did there was just try to clarify some language and also make sure that there was nothing that we missed, and happy to unpack some of those concerns as well too. So that's an update on our end.
Beautiful. Thank you, Mr. Wright. Mr. Kaufman, anything to add?
Yeah, thank you, Mr. Chairman. No, I don't think I have anything substantive to add right now. Just calling some attention to one staff comment that we'll go through when we get to that point.
Okay.
On the dissociation, there was a couple questions last time and some comments about that. I think we've worked through the mechanics of that. There, we could consider a few further finer tweaks to the language, but I think it's really close. Currently I'm really happy with the way that this has come together.
Excellent. Thank you. And thanks to everybody who worked on this. I know we've got University of Wyoming engaged as well. Mr. Moxery is here. Anything to add to what we've discussed so far, Mr. Moxery?
No, I other than to agree with what's been said so far, I did have some specific questions about the language of the bill here, of the proposed bill, but it sounds like the time to discuss that will be later, and I suspect that there'll be questions that can be answered fairly easily by those who are more knowledgeable about DAOs than I am, where I'm of course an expert in LLC law and business law and that sort of thing, and not DAOs. So my knowledge in that area just sparked some questions in my mind about the bill, but
great. Well, thank you, Professor. We'll have an opportunity, and we'll bring you in kind of on the public comment side after we walk through the bill and get those questions, because we want to make sure that we get everyone's concerns and interests addressed, and make sure that you're comfortable with it from the perspective of Wyoming LLC law, and we need to make sure that we get this one right. It's a tricky one, but it's really an important one, I think, for the select committee. All right. Anything else to add before we walk through the bill with staff? Committee questions before then? I don't see any. Okay. So with that, let's see, I think we're going to have Mr. Hopkinson join us. And Mr. Hopkinson, we don't need to go over what we've gone over before. And Mr. Wright gave us a kind of a thorough background on things. So I'd ask you to walk us through what's been updated, and then highlight staff comments and points that we need to consider as a select committee today when we're taking action on it. So with that, Mr. Hopkinson, the floor is yours.
Thank you, Mr. Chairman. Mr. Wright did highlight some of the changes that from the last bill that we've seen. So I won't readdress those, but in looking at some of the staff comments, kind of highlighting some concerns.
And sorry to interrupt, Mr. Hopkinson, we're on working draft 0.5, right? 21 LSO 263, working draft 0.5. Make sure everybody's got the right bill in front of them as we go through. All right, thank you. Go ahead.
That's correct, Mr. Chairman. Thank you. The first staff note comment on page 3 just highlights for the committee some concerns about the definition, majority of the members, and how that kind of interacts and conflicts with the majority of the members as defined in the LLC Act. And so that was something we wanted to highlight for the committee as well in its consideration of this bill, and how those should be defined. Membership interests at the bottom of page 3 doesn't address the algorithmically managed LLC. And so that was another concern that we wanted to highlight for the committee, is this particular draft as drafted didn't seem to address that particular issue. As far as structurally, this bill draft, as is different from the one that the committee first saw, we did place it in a new chapter, 1731-103, essentially provides that the Wyoming Limited Liability Company Act applies to DAOs to the extent that it's not inconsistent with the provisions of this chapter. And subsection B there just specifies and clarifies that this chapter does not modify any rule of law that applies just to an LLC that is not a DAO. I think the rest of this stuff was in the original. Going over to the staff comment on page 7, just kind of a minor thing we wanted to point out, that the term LAO isn't quite as readily recognizable as DAO as a decentralized autonomous organization, and LAO as a limited liability autonomous organization. That term doesn't appear anywhere else in the bill, and that may be something the committee wants to address. Jumping ahead to page 11, another staff comment there that the committee may wish to consider how paragraph 11 in section 1731-106 interacts with the newly created 1731-108. Essentially, that provides that the articles of organization and smart contracts govern all the following, which includes all other aspects of it. And 11 says all other aspects of the decentralized autonomous organizations. 108 provides that to the extent the articles of organization or smart contract do not otherwise provide for a matter described in 1731-106, which we just looked at, the operation of a decentralized autonomous organization may be supplemented by an operating agreement. So there was some concern about how those might interact, which would control. Just something to highlight for the committee. On page 12, another staff comment with respect to paragraph 3 of subsection A of 1731-107. Just some concerns about how the decentralized autonomous organization smart contracts have been updated or changed, how that would apply in the real world in a sense, and whether there needs to be some clarification there. And then on page 15, another staff comment highlighting a concern that the committee may wish to consider whether adding language about how a member withdraws from an algorithmically managed DAO if no terms and conditions are otherwise set forth is needed, because the bill doesn't, as this version at least, doesn't seem to address the question of withdrawal of a member for an algorithmically managed DAO if there's nothing otherwise provided. And then finally, on the last page, there was some concern that the last sentence at the bottom of page 17, dealing with the articles of organization and operating agreement, this provides that they are effective statements of authority, but then provides at the bottom there that if they're in conflict, the smart contract would preempt any conflicting provisions of the articles of organization. So there was some concern that there may be some issues with having a smart contract just freely able to violate the articles of organization. So those were just some of the concerns we wanted to highlight for the committee, and I would stand for any questions on this draft.
Thank you, Mr. Hopkinson. Committee, any questions? I'm going to go to the committee first to see if there's any questions. All right, seeing none, Mr. Wright.
Thank you very much, Chairman Rothfuss. We just circulated an updated draft. I don't know if that was received by the committee, but it did attempt to address some of the concerns flagged by Mr. Hopkinson and others and other colleagues that he has. Would it be helpful to just provide an overview of how we think we could rectify some of those concerns, or have attempted to?
So I think I'll walk through each of the concerns, and then we'll kind of discuss each of them and give you an opportunity to say how they were addressed one at a time, so we know where we're at, if that makes sense. That's probably how at least the clearest way for us to proceed, Mr. Wright.
Sounds good.
All right. Go ahead, Mr. Hopkinson.
And Mr. Chairman, we did send out an email with that attachment from Mr. Wright, so all the committee should have that in their email if they want to take a look at what he's talking about.
Yes, thank you, and appreciate that. Any further questions before we walk through? Okay. And I'd like to walk through each of the points, have a little Q&A and discussion, see what a proposed solution is, and do that before we go to public comment, so that those that are providing public comment have the benefit of hearing the proposed solutions, and then we can come back and perhaps revisit them. But with that, let's proceed through the key staff comments. So I'm on page 3, where the first staff comment discusses the majority of the members and potential conflict between what we use algorithmically and how existing limited liability defines a majority of the membership. And with that, Mr. Wright, let's go to you.
Yes. So on this one, we trimmed down the. I'm just triple checking. Yeah, we tried to align the language that was flagged by the LSO office in the updated draft. There may still need to be some work done there, but I think it's closer and hopefully does address some of the concerns that were flagged.
Okay. Yep. Mr. Kaufman, go ahead.
Yeah, Mr. Chairman, I can elaborate on that just a little
Please do.
bit. The original language so that the definition section for majority of the members, the last sentence of that section says, withdrawn members shall not be deemed to possess membership interest for the purpose of calculating majority of the members. So Aaron and I discussed this. My thought is that it's a simple fix, and Aaron has already captured this language in his proposed update, but instead of withdrawn members, it should be dissociated members shall not be deemed to possess membership interest. The only remaining question in my mind, candidly, Mr. Chairman, is whether or not we ditch just that language deemed to possess membership interests, and whether it would be cleaner just to say dissociated members shall not be included for purposes of calculating the majority of the members. And we could reference, there's a statutory section in the LLC Act 1729-602, which is the dissociation definition. That's as far as I think it needs to go. But I think, Aaron, am I saying that right? I think we agreed that this needs to be dissociated members, not withdrawn members.
Correct. And that's what I was referring to by saying we were hoping to align it a little bit closer. But thank you,
Okay.
Matt.
Excellent. And when we go through and work the bill, that sounds like a pretty elegant and clear change. So let's have that one ready as a proposed amendment. And I know that we've got and committee, you do have, in case you've been trying to find it, you do have this proposed language from an email from Mary Beth a little bit earlier today at about 9:30. If you want to pull that up, there's an attachment there that provides these details. Okay, thank you. Any further discussion or questions? Professor Moxery, do you have anything to add to that? Go ahead.
I did have one question with respect to section 102A 3 and 4, majority of the members, which the staff did comment on, and the next one as well. And the question, I suppose, is mainly driven by section 4, membership interest. It talks about how membership interest means a member's ownership share in a member-managed decentralized or DAO, which may be defined in the entity's articles of organization, smart contract, or operating agreement. And I wonder whether we have whether there's a default rule for this if it's not specified. And my first thought was that a per capita majority serves as a good, what we call in I guess in legal scholarship, a penalty default, right? So something that the entity is defaulted into if it's not specified anywhere.
Mr. Wright, Mr. Kaufman, thoughts on that?
I think that's a really great suggestion. I think that may make sense to clarify a default. I guess when drafting, at least as in my view, and I appreciate any feedback here. it didn't seem like at least membership interests were as closely defined in the LCX. So we tried to keep it a little open-ended to align with what we saw there. But I think that could be wise to set a default, especially given the fact that it may not be as clearly articulated in some of these software systems, and be happy to consider including that or adding that.
Thank you, Professor Wright. Professor Moxery, any follow-up thoughts on that?
No, I think I think that would cover it. Make it just to avoid any ambiguity that might creep in. That should work.
Okay. And let's make a note of that. And if we can come up with a clear and direct way to do that now or when we're working the bill, that would be great. If not, we can make a note to put that amendment together for future consideration. All right. Anything else on page 3 and then going on to page 4, the staff comments there with regard to majority and membership interest? All right, seeing none, let's go on to the next point for a little quick discussion, which gets us to the staff comment, which is pretty brief on page 7. This is the only place in any way where Lao is mentioned. Thoughts on that, Mr. Wright?
I think it was a very fair point. I don't have a strong opinion on it. I was merely trying to capture how some folks in the ecosystem currently refer to some of the DAOs that are wrapped or deferring to some sort of limited liability entity. But it doesn't really. I don't feel strongly one way or another about it. I don't know if other folks do.
Okay, thanks. Committee, thoughts?
Mr. Chairman, for what it's worth, same for me. I don't have strong feelings about it. If, it's fine the way it is with me, or if we want to strike Lao, that's fine as well.
Okay. We'll get to that. We'll see if there's any motion. Professor Moxery, any thoughts on that? Do you care?
The same. I remember when I first read this a month or so ago, I thought, what's a Lao? I don't know what that means. But otherwise, I mean, it again, I suppose I would slightly err on the side of removing it only because it's the only place we don't know what it means. But again, not a big deal. Perhaps it can be defined somewhere in the bill, but.
Okay. Anyone else want to weigh in on that before we move on? Yes. Hi, Carla. Go ahead.
Hello.
Professor Reyes, go ahead.
Thank you, Mr. Chairman. I just want to echo Aaron's comments that folks in the industry are using this term, and it might be useful to them to be able to continue to use what they customarily use rather than have to change. But that's all.
Thank you, Professor. Do you have any thought? I mean, it is a little bit hanging out there. We could define it somewhere else or reference it or something. Any thoughts on how to go about that?
No, but I don't think it would be hard to do if that made it easier to allow industry to continue to use what they use, because Aaron's right. And I knew what it meant for what it's worth.
Sure.
but I can see where folks reading it who aren't familiar with industry wouldn't necessarily know. So I understand the point, but I don't think it'd be hard to go the other way rather than strike it, add a reference that explains what it is.
Excellent. Well. Okay. Thank you, Professor. Senator Nethercott.
Yes. So I don't feel particularly excited about it either in or out, but I do think it's better practice to strike it if there's not a definition within statute, because it is a different meaning with a different definition. And so if we're going to include it, which it sounds like there's general need from industry that for the whole purpose of the bill and why we're doing it, to have it in there as this separate concept. So while we're discussing this, and as I'm talking way too much as a good politician and lawyer, buying you time, you need to give us the language for the definition from those that know what allow is and feel confident that they can define it, to be prepared within the next few minutes to have a definition for us to amend into this bill, because this is our last meeting. So I'm continuing to talk to buy you time, but happy to hear that definition. Thank you, Mr. Chairman.
Thank you, Senator. And the kind of strange thing about our law and DAO is with this specific bill draft, the way it's drafted, every DAO is allowed, because the LAO is a DAO that is an LLC. We created only a category of a DAO that is an LLC. So for our bill draft, they're actually the same. They don't necessarily have to be the same, but our construct makes them the same. Yeah, go ahead, Mr. Wright.
Thank you very much, Co-Chairman Rothfuss. Yeah, I mean, I think one quick definition could just be, a decentralized autonomous organization as defined in the bill, organized under this subchapter probably would suffice to define it. The one argument I would say for using that would be if a group of folks wanted to indicate to the public that this wasn't, a fly-by-night DAO, this was something that actually provides limitation of liability, then the moniker LAO may, and it's hypothetically indicate some prominence or significance, right? So that would be kind of in the camp of including it. I don't know if that definition is clear enough, from other folks that are more knowledgeable about Wyoming's drafting standards and other practices.
Thank you, Mr. Wright. Senator Nethercott, any follow-up?
No, I think sounds like fairly decent as long as everyone agrees that that's the right definition.
Great. Professor Reyes, you good?
Yeah, I was just trying to nod my head in
Perfect.
like extra exuberant agreement with both your comments and Professor Wright's comments. I
Excellent.
think the definition works fine, the one he provided. Yeah.
Perfect. Okay. Any further thoughts or concerns on that topic? We'll get back to it. Yes, Mr. Diedrich, go ahead.
Thank you, Mr. Chairman. I would like to ask whether the Lao DAO equation is really as strong if you just at the same time propose that only if a DAO can be covered by this law. That's what I wanted to ask.
Mr. Diedrich, that didn't come through particularly well, so I didn't quite get that question.
So my question is the equation of that every DAO is a DAO or vice versa really that strong? If you also want to write into the bill that the bill only covers DAOs where you can change the code, and that's pretty strong and might break that link.
Gotcha. And as this legislation is drafted now, and again, correct me if I'm wrong, Mr. Wright or Mr. Kaufman, every LAO is a DAO and every DAO is a LAO if you are going to authoritatively call it that under Wyoming statute. Doesn't mean you can't call something like a lowercase DAO or whatever else. But since we're only creating a class of LLC as a DAO, then for us, for now, every LAO is a DAO and every DAO is a LAO. That doesn't mean that's the future. But I think there's a full equivalency. Is that accurate, Mr. Wright, Mr. Kaufman?
Thank you, Co-Chairman Rothfuss. Yeah, yes, that feels correct to me. Your interpretation. It's not saying every DAO that ever may be created is a LAO. I think it would just say if you have gone through and registered in accordance with the supplement, a DAO, or selecting that designation, you can choose to either call yourself, XYZ, DAO or XYZ, LAO, with the latter indicating that it's, a recognized limited liability entity that's sitting behind that structure.
Excellent. Thank you, Mr. Wright. Okay. Anything further on that before we move on? All right. Seeing none for now, let's move down. Looks like we're on page 11 for the next staff comment. All right. Mr. Wright, we've got some potential interaction concerns between Romanet 11 and 1731-108 in LLC statute. What's our remedy?
So we didn't think that this was actually in conflict here, but obviously would love to hear other perspectives here to know if we should narrow it down. The point of 11 was just a kind of broad catch-all. If that is too broad, I'm sure we could narrow it down a bit. But what in effect this provision is just saying is that in the articles of organization, you can define how this entity will operate, and that includes the different categories of activity that are articulated above 11, and then 11 just kind of serves as a catch-all to memorialize it, just like you would in any other LLC. You can define, in a document how the LLC will operate.
Gotcha. Thank you, Mr. Wright. And I think the concept here, at least as I read it, when you've gotten page 9, paragraph C, except as otherwise provided in this chapter, the articles of organization and smart contracts for every decentralized autonomous organization shall govern all of the following. 11 says all other aspects of the decentralized autonomous organization. So it basically says that the smart contracts shall govern everything related to the decentralized autonomous organization. But then we get to 108, which says, to the extent the articles of organization or smart contract do not otherwise provide for matter described, the operation of a decentralized autonomous organization may be supplemented by an operating agreement. But you've just said above that the smart contracts govern all. So I do see a little language challenge there. Go ahead, Mr. Wright.
Yes. So the notion is you can include those provisions in the articles of organization or the smart contracts if they're not provided. And let's say you wanted to use a more traditional operating agreement, you could do so. So I'm not sure there is a conflict, but obviously happy to tighten up the language to clarify that. But again, the thought would be so that the public benefits all the rules related to how the organization operates, whether that's software in the form of a smart contract and or any other provisions that may deal with some of the matters up above will be available in the articles of organization. But at the same time, if there's a need for an operating agreement of some sort, we didn't want to preclude that flexibility. We could imagine hypothetically some instances where folks may want to preserve certain information, make it a little bit more private, et cetera. And an operating agreement obviously does a great job at that.
Yeah, I can certainly see the intent, and maybe there is a way to tweak. And Mr. Allen, I'll get to you in one second. Maybe it's something on 11, all other aspects of the decentralized autonomous organization as provided, or something along those lines, so that it helps to complement to the extent the articles of organization do not otherwise provide, something along those lines, so that there's a complementary language that allows them to go hand in hand. And maybe this isn't a problem. Maybe others see it as consistent. Mr. Allen, I saw your hands up, and then Mr. Kaufman. Go ahead, Mr. Allen, and introduce yourself, since this is your first time in the show, and thanks for all of the work that you've put into this and the rest of our work. But go ahead, Mr. Allen.
Thank you. My name is Christopher Allen. I'm with Blockchain Commons, a Wyoming benefit organization for open infrastructure for blockchains. I wanted to speak to this particular section, but I think it's indicative of a distinction here. So I apologize for this minor definition education thing I have to give some context here. DAOs have come historically from the Ethereum community, which is a state-based blockchain. So what it does, a state-based blockchain has all of these data elements and things of that nature that can only be changed if the scripts say that they can be changed. And that's basically the function of how that family of architectures, which includes a lot of other variants of blockchains. But the other big variant of blockchains is key-based blockchains, such as Bitcoin, which of course is the largest blockchain. and oldest. So they do not do smart contracts in that fashion. So when I read this particular section, the smart contract shall govern all of the following, I basically get a list of things that you can do with an Ethereum smart contract, where what a Bitcoin smart contract for a DAO would do would be, here are the keys that you use to show authority over those functions or to make changes of those functions. So a Bitcoin based DAO probably doesn't automate the rights and duties. It basically says the holders of these keys, can update the rights and duties, or this is the rights and duties by pointing to it, and then basically saying these are the keys by which it can be changed, or you can prove that you have the rights and duties. So was fine in some of the earlier drafts or whatever, that we didn't quite nail that difference of the two kinds of smart contracts. But when I read this shall govern all of the following, that sort of reads to me that's for an Ethereum style algorithmic managed LLC. Whereas with Bitcoin, you're probably going to do it with a member managed, where the LLC defines what keys get to control, user keys, member keys, get to control these different elements, and what kinds of votes are necessary, and multi-sigs and stuff that are necessary to prove 50% ownership, or any of these other different types of things. So I'm a little concerned we're baking in the algorithmic version of the LLC, and we may be precluding the key version, which is for the membership managed. And this is technical. You need to have an understanding of both kinds of blockchain architectures. And ideally, there may be a third form of blockchain architecture emerge in the next 10 years. Ideally, it should be flexible enough that it works for the future as well.
Thank you, Mr. Allen. It's a good point, and I think we're going to, there's the possibility of addition of some language there. There's the possibility of trying to clarify smart contracts or expand it, and we'll have to figure out how to address those circumstances. Mr. Kaufman, go ahead.
I think, Mr. Chairman, so just a couple comments on that point. First of all, we've organized this supplement to be only member managed LLCs. So I think the algorithmic description is with respect to the voting and control mechanisms, but these are all designed to only be member managed. So that to me is an important distinction. Mm-hmm. The other thing that I think is really important here is we're sort of creating, the LLC Act originally kind of creates a hierarchy of documents, because you don't have to have an operating agreement. You have to have articles. And obviously the operating agreement can expand. They can't conflict, but they can expand on the articles. If you don't have provisions, then you default to the statute. And so we're mimicking that type of hierarchy in this, where we're saying you got to have articles, a smart contract, and then you might have an operating agreement that builds or expands on those. So again, I just wanted to get back to the point a few moments ago that in my mind, the 1731-108 doesn't really conflict, because the operating agreement is elective in the first place. So it might expand on that, but to the provision above the right above the staff comment with all of their aspects of the decentralized autonomous organization, that to me is a prescriptive statement, because by definition, the articles and the smart contract are going to have to govern those aspects of the entity. So I just wanted to clarify that point, Mr. Chairman, that I'm still not quite seeing the conflict there. Maybe we could add some words to make that or bolster that so it's a little more clear. But right now, I'm not seeing the conflict.
Thank you, Mr. Kaufman. And what you said, I think actually clarifies it for me, because supplemented then becomes the key word on line 19, where it's not governing, it's supplementing. And I think the way you just stated that helps to clarify that. All right. Yep, go ahead, Professor Moxery.
I agree with that, and I might just add a kind of a very quick point, which is that generally with any type of entity that's created by the state, that whether it's by right someone can apply for it or not, there's a hierarchy and authority within the entity, and typically in LLCs it's the articles of organization, and then it's the operating. So first it's statute, then it's articles of organization, and then it's the operating agreement. And I think the language that's currently here fits with that perfectly. So I confess I don't see a conflict either. If something in the operating agreement somehow conflicts with the articles of organization or statute, it's just not valid because the one higher in the hierarchy trumps.
Makes sense. Good deal. Okay, excellent. Let's move on to the next point for discussion. And just to be clear to everyone, we will go to general public comment as well, and we'll have an opportunity if anyone wants to weigh in on any of these, but I just wanted to walk through them before we get to that general public comment, although I think a lot of that public comment is kind of coming as we go, which is great. All right, so looking at page 15 now, we see staff comment lines 10 through 17. So specifically how a member withdraws from an algorithmically managed DAO if no terms and conditions are otherwise set forth. Do we need clarification on that? So I think one of the concepts here is if the algorithm doesn't provide me with a clear context for how to withdraw, how do I withdraw? Anyone have any ideas on that? Go ahead, Mr. Wright.
Thank you very much, Senator Rothfuss. So in the latest version of the draft, and Matt and I worked through this, we mirrored some language in the current LLC Act, which says that you're able, through a clear statement, to dissociate. So instead of withdrawal, as Matt noted before, in the latest draft, we've modified the language so that it's more closely aligned with the LLC Act and refers to dissociation. We expanded some language in section, let me just get to it, sorry. Where is that? In section 114 that says why am I, oh, there it is, 113, sorry. That a person has the power to dissociate as a member at any time, rightfully or wrongfully, by withdrawing as a member by express will in accordance with the LLC Act or section 1729-602A, A1. If no terms and conditions for dissociation are set forth for an algorithmically managed decentralized autonomous organization, a member may dissociate in accordance with this section. So two things happened here. One is we aligned it more closely with the LLC Act, and two, we did provide a way for somebody to indicate that they no longer want to be part of an algorithmically managed DAO if it's not otherwise provided for in that hierarchy that was just described, the articles of organization, the operating agreement, so this becomes kind of the default rule.
Excellent. Now I see that new language. Incidentally, we do have, for those watching, this updated draft and the updated language is available as Appendix 302 in the committee material that is available at wyoledge.gov. So you can see that if you need to. Thank you, Mr. Wright. Anything to add there, Mr. Kaufman? Okay.
No, Mr. Chairman, I think that's great.
All right. And the next, I gotta get to the right.
A quick question, if I may, Mr. Chairman.
Go ahead, Professor.
I've not seen the new language. I'm still working off draft 0.5. Yep. But my understanding of what Professor Wright said is that language has been added to allow for members to dissociate from themselves from a DAO unless the operating agreement or the governing documents of the DAO say otherwise. Is that a correct understanding?
Mr. Chairman, or excuse me, Professor Wright, go ahead.
That's correct, Professor Ascari.
Got it. Great. Thank you very much. That was the one concern I had, and that addresses it. Thank you.
Excellent. Okay, I believe we're on to the final staff comment, page 18 at the bottom. So I think this gets to the hierarchy concept, lines 20 through 22, page 17. The smart contract shall preempt any conflicting provisions of the articles of organization. And I'd take comment on that, Professor Wright.
Exactly. So we were trying to articulate a hierarchy, make sure it was clear. There was just a question as to whether or not, due to the language, if the smart contract violates the articles of organization, what should preempt? We did our best to, in the updated version, to narrow that a bit. So the thought would be, if there's a conflict between the code that's managing one of the activities mentioned in, just scrolling up, in section 106, things like rights and voting rights or transferability of membership interests, and the language in the articles of organization is not as precise to how the smart contracts operate, then the smart contracts, in our view, should trump. They should have, they should sit higher in the hierarchy. But my sense was there was some concern about other kind of mandated requirements in the articles of organization that you wouldn't want the smart contracts to trump. And that's what we tried to carve out here. So we added a clause at the end of that sentence, except the articles of organization shall preempt any conflicting provisions in the smart contracts as it relates to section 104 and 106A and 106B. So we think that addresses those concerns. If there's other concerns, I think we could address it via an amendment to the language to just carve out or clarify further.
Great, thank you, Mr. Wright. Any questions on that or discussion? One question I have about the hierarchical concepts, I guess, gets to the discussion we had before, and I think the language that you added about having to have the capacity to amend the smart contracts in some way might be the solution, but it gets to the idea where the smart contract starts to operate in an unintended way. And maybe we'll say it even violates the letter or spirit of the rest of the articles. And the members somehow want to change that or stop utilizing the smart contract, but the smart contract seems to have priority over almost everything else. So if it's still operating and it's still effectively operating, but it's not doing what is intended, how does the organization remedy that, since the smart contract seems to be the winner?
So that's accounted for in, let me just flip through and find the language. I think it's on page 15. If they do want to change the underlying smart contract, the statute, I just need to find the language, apologies. The supplement mandates that if there's going to be a change in the smart contract, then the articles of organization needs to be amended. So what I was envisioning, and obviously interested in any feedback as well here, would be there's some smart contract based system that folks are not happy with. They want to upgrade it, just like they would upgrade any other form of software. And they decide using whatever procedures are articulated for the DAO, either in the articles of organization, the operating agreement, or the smart contracts, to go through that upgrade process. And then at that point, they'd be obligated under the supplement to amend the articles of organization to identify the new smart contracts that are being used. And so I think that enables folks that do run into an issue, that want to effectively use like a new system to govern themselves or govern the affairs of the LLC, to take steps to amend that, and also take steps to alert the public that it has been amended. So
now, is that Mr. Wright, is
Sorry.
that paragraph one of the paragraphs that you just provided for conflicting provision exemption to or not?
I don't think it is in conflict.
Okay.
Yeah, but I don't know if others share the same view.
Mr. Kaufman, what are your thoughts? Do you see what I'm saying? And do you think that you can get yourself out of a bad smart contract, so to speak, through an amendment to the articles?
Yeah, Mr. Chairman, I want to address your question directly, but I'm not 100% sure I'm seeing exactly what you were referring to on the potential conflicts.
Let's see. Well, the concept, and it gets to let's see, where was Mr. Wright? I was looking at two different documents, and page 15, Mr. Wright, and it's
yes, the language that I was referring to before is, I just found it. I just scrolled away from it. Sorry. I think
No
it's
worries.
107A3. So in articles of organization shall, so it's a requirement, be amended, when the decentralized autonomous organization smart contracts have been updated or changed. So if there's an issue with the smart contracts and the members of the DAO, the members of the LLC agree to upgrade those smart contracts, they have the ability to do so. And then they're obligated under Section 107 to amend the articles of organization to reflect that change. So that means that those articles of organization would have precedence, and the updated smart contracts, assuming that they went through whatever process the organization decided and agreed to, would then effectuate the update.
so my concern there, and that was where I was seeing if 107A is one of the ones that you gave, so it doesn't have priority. So if I don't know how when you talk about the layering, where as a first approximation, the articles and the smart contracts are equal, but when in conflict, the smart contracts win. If you've got a problem with the smart contract, I don't know how you can amend the articles of incorporation to trump the smart contract when the smart contract trumps the articles of incorporation by default.
I see, but if they're applying or filing to be an LLC under this supplement, there's a requirement that they're upgradable, particularly if it's one of these algorithmically managed organizations. So that should mean that they'll have that ability to do so. If we want to create kind of a hierarchy about smart contracts and amending those smart contracts, we could presumably add some language to that pretty easily. I just would need to give that a little bit more thought and maybe discuss with some others.
I see Professor Moxery wants to raise his hand, but it seems to me that honestly, just adding to your new draft at the very end, where you've got 1731 106B as your last clause, you could almost just add 1731, what is it, 107A?
Yeah.
As an additional preemption, I think, unless I'm missing something, which I could be doing, but that was the first thing that came to mind there. Professor Moxery.
So I have a bit of a more higher level concern about this, and that's that typically the articles of organization serve as a notice tool, a tool that puts the world, the public on notice that the state has authorized this entity to exist. And here are the terms and conditions under which this entity will operate. And typically the articles of organization are pretty generic. And so I'll acknowledge that in most cases, I don't even see a conflict between the articles and a smart contract, because the articles would say, well, we're run according to the terms of this smart contract. But if there is a conflict, I have some concern about the smart contract trumping the articles, because presumably the smart contract is not, the terms and details of the operations of the smart contract are not made available to the public like the articles of organization is. So someone wanting to do business with one of these DAOs or LAOs is not able to go out to the Secretary of State's website, look at the articles of organization and understand this is what this entity is about. They can't look at the smart contract because the smart contract is not available. So as sort of perhaps the right word for it is theoretical matter. I'm not sure that's exactly right. But I think to in keeping with the purposes of having the public be put on notice by the articles of organization, I think having the smart contract trump is somewhat problematic in that sense, right? The sort of the public state authorized version of this entity is what should trump. It should, so statute, getting back to what I said before, statute obviously trumps. Then the next thing that the state is creating is this entity with these specified articles of organization. Something that the members do within the entity itself, I don't think, and I'm willing to be convinced otherwise, but my first instinct is that should not trump the entity created by the state and its members that puts the public on notice as to what this entity is all about, what it can and can't do, and so on.
Interesting. Professor Wright, go ahead, and then Mr. Kaufman.
Thank you so much, Senator Rothfuss, and thank you so much for the comment, Professor Mascari. I think that is a great point. One just table setting way to think about this for smart contracts on public blockchains, they are publicly available. And what tends to happen, like other forms of open source software, people will not only just have the smart contracts available, but there'll be robust documentation around it. It almost acts like a standard over time, where people kind of understand, oh, this is XYZ smart contract. This is how it operates. We understand the kind of rules of the game. So one way to, I think, address that concern could be just to add a clause at the end that just says the smart contract, if available on a public blockchain, will preempt any conflicting provision. And that would, I think, address that concern, make sure that the public is fully aware of the rules, either in the articles of organization or in the underlying software system, the smart contracts. But at the same time, if you're organizing and those smart contracts are private, then the public document obviously should take precedence. Maybe that's a path forward there. I hope that made sense. I know you're diving into this, and happy to unpack anything if that didn't address your concern.
Yeah, I think that does make sense. I'd want to think about it just for a little bit, but that certainly satisfies the notice provision, the notice purpose of having articles out there and be public documents and so on.
Mr. Kaufman.
Mr. Chairman, I just wanted to reiterate, those are all good comments and things we've talked about. I wanted to direct everybody's attention to 1731-106B. We do already indicate in the draft that the articles have to include a publicly available identifier for any smart contract. So that notice provision is somewhat already contained. And then the idea there is just what Professor Moxery was saying, that this is unique in that we're going to have sort of two, required source documents to initiate one of these entities. And so that as a matter of notice and fairness, that smart contract should be available. I just wanted to point that out to the committee. Having said that, I think that the solution that's being posed is fine with me.
Yeah, one point that Mr. Diedrich made is, the source has to be public, not just a pointer as being public or something along those lines. And I think that the way this language is written, I could point to a contract that nobody could read. And I think that would still probably be meeting the letter of the law potentially if it's a smart contract, but it's sort of a closed source smart contract. So we have to make sure that somehow we're contemplating that.
Go ahead. Sorry, Mr. Chairman.
Yep.
Yes, thank you. That's two different things even. But obviously with Ethereum, there is a very low level representation of the smart contract is publicly available and runs on the blockchain. But I want to fully second what Mr. Wright just proposed, to have an obligation to have special rights for the smart contract to trump. Only in case it's publicly available, but it must be the source code. In Ethereum, it would be Solidity, for example, which is not automatically available. and also an identifier, for example, in the form of a hash of that source code, allows you to do certain things to prove later that this is actually the source code when you reveal it, but it's not automatically making the source code public. So, but that should be easy to articulate, I think, and easy to fix. And of course, Lexon would be the solution to actually have both being one.
So, Mr. Diedrich, publicly available source code concepts, I mean, that's the key that you want to see here. So not just that the smart contract's available, but the smart contract and source code are publicly available?
Yes, because there is a difference between the actual code that's called opcodes that runs on the Ethereum blockchain as an example, which could be said to be a publicly available version of the smart contract. That would be fully correct technically, but it should be the source code because that is what is actually, even for programmers, understandable. That opcode that is actually public is not necessarily, it's very difficult to decompile and read.
Gotcha. Thank you. All right. Anything else on that point? All right. Any further discussion before I go to general public comment to see if there's any other concerns that we need to take a look at and raise? Senator Dockstader, I see your hand, but it doesn't look like you're waving at me. Okay, good. All right. Seeing nothing from the committee, let's go to general public comment. And before we start general public comment, note that we're already a little bit behind on time and we've got a few other big topics ahead of us. So let's keep public comment concise and on point and new issues specifically. And with that, let's go to Mr. Christopher Allen. Go ahead, Christopher.
Thank you. Christopher Allen, Blockchain Commons. I'm still concerned that, this contract doesn't, this law and the smart contract stuff seems to be very Ethereum specific and, used by blockchains like Bitcoin or other UTXO blockchains, which manage keys and grant authority to do different types of things, or to be able to represent the company's authority to do different types of things is not really in here. And I feel it's a lost opportunity if we, don't try to address that. And I'm not really seeing an understanding from the different parties of, that half and potentially larger half of the blockchain community as far as technology architecture choices. There's no word key in this entire section. There is no word about, authorized signatures, which is something that a Bitcoin-based Lao might use. And I just feel like it's a missed opportunity. So I'll leave that there.
Thank you, Mr. Allen. Appreciate that. Yeah, go ahead, Mr. Wright. Response on that?
I think Chris is making, or Mr. Allen is making a really important point. I do think it can be addressed by just amending the definition of smart contract in 102A8, just by including, right now it says an automated transaction or any substantially similar analog, which is comprised of code, script, or programming, or a programming language that executes the term of the agreement. We probably could I think we could generalize that to address Mr. Allen's point and include some language there. I don't know if you have any thoughts or anybody has any thoughts on how to do that.
Thank you, Mr. Wright. Mr. Allen, response quickly.
I think that would be a good start. I still feel like there's an element. Even like this last discussion, I'm kind of, going, you can in say a Bitcoin way architecture of doing a allow, you would have some kind of authority granted to a group of keys to change the articles of incorporation or to dissolve it or change membership, etc. And the nature of those algorithms and the keys would do the thresholds and do the voting to say, yes, that change happens. Here is the new articles of incorporation signed by the quorum of the company, the authorized quorum of the company. So it's just a different style of things, and I feel like it's a little bit bigger than just the smart contract definition change. But I would be happy if at least the smart contract definition was at least better, so we could try to fit it in. I mean, the reality is that there are most of the DAOs that have been implemented to date are Ethereum based. So there are very few that have tried to do it with Bitcoin because Bitcoin needs a allow underneath it. The existence of this legislation might allow some of the a key based UTXO based approach to creating a DAO. But to be honest, again, 99% probably of things up to this point have been done with sort of the Ethereum family smart contracts. That's it.
Thank you, Mr. Allen. And I think it's worth contemplating if there is a way that we can elegantly change the definition of smart contract so that it incorporates key-based agreements, key-based consensus, something along those lines. That's not a traditional use of smart contract, I guess, but it'd be great if we could do that somehow. All right. Anything else on this point specifically before going to Mr. Marr? All right. Mr. Marr, welcome. Please introduce yourself. And let's keep comments brief because we are about 15 minutes behind, maybe a bit more.
Hello, can everyone hear me?
Yes, we can.
Wonderful. Yes, my name is Brendan Marr. I am an MIT Media Laboratory alumnus from 1998 and a computer scientist. I'm also a member of, or a mentor for the LAO, a DAO, which you all know, and I'm part of the MIT computational law ecosystem. I'd like to express a number of comments that I hope to tie together the issues that have been stated thus far. I would say first off, wholehandedly, I do believe that what we're proposing here will have a tremendous impact on the entire ecosystem for the United States and the world. And this is all very exciting stuff. And I think this is great going forward. There are some things that I think do need to be amended. I do agree wholeheartedly with Christopher Allen on his latter point regarding smart contracts and how we can actually broaden this to the larger ecosystem. So a couple things to note, and they would be this. First, regarding thinking about smart contracts and hierarchies, it's very important to understand that we can encode a lot in smart contracts algorithmically. However, we have to allow for the fact that certain things will not be able to be encoded very easily in a smart contract, and we need to be able to have ways of catching those things that fall through the cracks. And this gets to the operating agreement. The smart contract is in control, or the operating agreement is in control. My suggestion might be that maybe we just simply have the option to state which is in control. This class of a DAO, the smart contracts will be for other DAOs. It would be the other way around. This becomes very important when we think about things we've been talking about earlier in terms of systems that are dynamic, self-driving cars, and things like that. Because when we talk about processes and smart contracts and entities that govern real-time systems, we're not always going to be able to have the human in the loop. So we actually smart contract to have control and govern things. There's when you're not going to be able to, etc., to on the operating of those things that fall through the cracks. Particularly getting to simply hear about section 31104, which talks, I believe, a piece of understanding how to resolve some of these issues deals with C104 Part D, where it talks about the.
I think Mr. Marr may have vanished. Mr. Marr, are you out there? I do not see him. Mary Beth, do we have any other public testimony? We'll try and bring Mr. Marr back in when he gets a successful connection.
Mr. Chairman, we do not.
Okay. Anyone else that has already provided testimony want to provide any additional quick thoughts? Oh, Mr. Marr is back now. Mr. Marr, welcome back. And
am I on?
Yeah, your bandwidth is not very good though right now. You're struggling.
Oh, great.
Yeah, you're still really struggling there.
Sorry. Thank you so much.
Yeah, Mr. Marr, we don't have you very much there. We've got a lot of lag. Let's check back in with you later and get the rest of your thoughts. I think I get some of the sense of it.
I'll try to work through it. Take a walk.
All right, Mr. Marr, we're gonna move on in the interest of time, and we'll get back and collect your thoughts a little bit later when you've got some better bandwidth. We're still showing up bad, so Mr. Marr, we'll bring you back on a little bit later and visit with that. Anyone else have any thoughts? Go ahead, Mr. Dietrich, welcome. And please introduce yourself. I don't think you've actually introduced yourself yet, despite the fact that we've heard from you a couple times.
Okay, thank you, Mr. Chairman. I'm Henning Dietrich, CEO and founder of Lexon Digital, and we're working on a smart contract language that is readable without any IT knowledge, just as normal language. And that brings me exactly to the point that I would like to ask, that the draft is crafted in a way so that the case that the language of the charter and the smart contract is actually the same. And I would hope that there's no oversight in that the draft kind of stipulates that it has to be two different things. That's what I wanted to ask for.
Oh, okay. Mr. Dietrich, so is that an allowance or a requirement, first of all?
So it's an allowance that I'm asking for sure.
Okay, I understand. Okay, so you want to make sure that the two can be one, basically, as long as they meet both interests. All right, Mr. Wright, go ahead.
I think that's a great point, and the work that Henning and others are doing in this field, I do think point toward the future. I don't think there should be any issue because again, the operating agreement can be written in a natural language. All it would need to do is identify what that underlying system is, like we were describing earlier during the meeting. So my understanding is that is going to be feasible, at least even in systems like the ones you're contemplating, and therefore I think it's already accommodated in. I know that was in my mind when working through the proposed supplement and bill.
Okay, thank you. And I'd ask Mr. Wright that we reflect on it though and make sure that there isn't anything that would prohibit that type of approach. Thank you. Mr. Allen, briefly.
Thank you for letting me add in a little thing. I'm realizing that one of the things that's missing here that may be causing some of these problems is there is really no discussion of authority. I mean, a corporation is authorized by the state with a signature from the Secretary of State. That's an authority that is then granted to allow them to do certain types of things, and then that in turn is given authority to the initial registration and then down the line articles of incorporation, et cetera. And then those define who has the authority to do things like sign checks and change things, do new articles of incorporation, whatever. There is no use of the word authority in this here. You know, and when I was talking about the difference between these things, there is a in the key-based systems, they're all about granting the capability, the authority to do different functions. Who has it, whether or not it's a vote or a person or some group of quorum or some rule or whatever has the authority to do X. And that's kind of missing from this. And I'd love it if the Secretary of State is where it started. So
no, it does.
That's
oh my God.
Thank you, Mr. Allen. Mr. Wright, go ahead.
I think that's also a great point, Mr. Allen. My understanding, and I don't know if Professor Mascari has any thoughts here, but that tends to be addressed in underlying documents, not the chartering documents. You know, who has the authority, how certain, certain questions related to the things that you flagged would be addressed. So I do think it's contemplated. It's going to be available if somebody wanted to create such a system, even assuming it wasn't expressly provided for, let's say in the articles of organization. It can be provided for in the way that the smart contracts operate. Somebody could articulate it clearly in the articles of organization or in an operating agreement separately to kind of supplement that so that those questions are clear. So I do think it's addressed, but maybe not as expressly as you may think is needed, but it shouldn't create any barrier or problems to set up the arrangement like you were describing.
Great, thank you, Mr. Wright. And I do think one thing, the language structure it has to be based off of in parallel to what the LLC has in statute. So the same way that authority is transferred and recognized with articles and supplemental materials, we have to make sure that's parallel. And I think that's part of the reason why authority isn't explicit, because we don't incorporate that into the other LLC statutes, but we need to make sure that we're addressing the interests that Mr. Allen's laying out. All right. We need to get concluded with public testimony as soon as possible. Mr. Marr, we'll give you one more shot at good bandwidth, but I want 2 minutes on your points if we can. So what are your best 2 minutes here, Mr. Marr? You're muted.
1731-104 might be amended to include, instead of just DAO in the name, to include a set of alphanumeric characters that resolves to including a DAO. This allows for a segue into keys as a notion of control and authority. So that's one of my comments. Is that clear? Okay. And the other comment is, it was mentioned that source code may be publicly available. I do think that that might be problematic because not everything will be source code based in the future. Certainly, AI does not deal with source code when it is operational. So that will further take more discussion going forward. I want to be brief. And my final comment is, if there's any way to, at this late hour, make this a reference to series LLCs as well, that would really open the door to a lot of opportunity and possibility. But I might be extending my reach at this point. I'll take any questions.
Thank you, Mr. Marr. Any questions for Mr. Marr? All right. Seeing none, any final quick thoughts before we close public testimony? All right. Seeing none, public testimony is closed. Back to the committee. If we can just clear up to the committee at this point.
Move the bill.
All right, we've got a motion on the bill from
Second.
Representative Lindholm, and we've got a second from Senator Nethercott. All right. Committee, any discussion before we work through the bill on overall thoughts?
Question on the bill.
Representative Lindholm wants to kick the ball down the road quickly, but we probably have a couple of amendments. Yep, go ahead, Mr. Kaufman.
Mr. Chairman, I just wanted to ask a quick question.
Yep.
Given the craziness of COVID and what the legislative schedule is going to look like, how are bills exactly going to progress from here? Do we know?
Absolutely. So we don't know is the first answer to that. But in all probability, which I can't go beyond probability, the legislature will be sworn in the first week in January and the second week. And then on January 12th, we will open the legislative session, adopt some sort of rules, but that won't be in person. Most of the people will be Zooming in for that. And then in all likelihood, we will push pause for some period of time. We may have a session electronically to address some high priority bills. That would probably be over Zoom, but unlikely that we would get too deep into the weeds and really run a lot of legislation and work all of the committee bills at that point in time. And again, that's up in the air. We haven't decided on that. And then the question is, at what point would the legislature actually go into session? It is my expectation that this select committee will probably reassemble and have an opportunity to work these bills further. But what I would like to do is pass the bills in good form today, because this is the end of the 65th legislature, and it would be good to have sponsored legislation, if we're comfortable sponsoring it, that we could work if we did have a legislative session that happened relatively quickly. If that doesn't happen, we'll have more time to work on it. We'll basically set aside a bill that we passed, have an opportunity to work it further into another form, have another bill that we could potentially take action on to bring to the legislature. Does that answer your question, Mr. Kaufman?
Yeah, thank you, Mr. Chairman.
Absolutely. And Majority Leader Dockstader?
Yeah, I'd like to follow up. Committee bills will be given priority. Do our co-chairs perceive this bill as a priority bill?
Majority Leader Dockstader, I see this as a priority bill if it's ready, if we feel it's ready. No question to me, this is high priority, but at the same time, in my view, if we're doing a special session or something along those lines, it needs to be pretty perfect. We need to be comfortable with it for it to be a high priority bill. All right. With that, let's try and work through the bill relatively quickly, see what we can get done. We've got a motion and a second on the bill. Let's get it into good shape and then recognize that we can work on finer tuning some of the amendments and continue work on it, particularly if we don't have an immediate session. So with that, I'm going to start walking through the legislation. Are there any proposed amendments on page 1? Any proposed amendments on page 2? Mr. Kaufman.
Yeah, Mr. Chairman, I would propose an amendment on page 2, starting on line 1. So that language reads dissociated members. And if LSO needs the statutory site for dissociated member definition, it's 1729-602. So dissociated members as set forth in that section shall not, I would propose it just read be included for the purposes of calculating the majority of the members.
Mr. Kaufman, which bill or draft are you working off of?
0.5.
And you said this is at the top of page 2?
Oh, I'm sorry. Top of page 3. I apologize.
Okay. Page 3. Go ahead.
I'm sorry, Mr. Chairman.
No worries.
So where the last sentence of that section says withdrawn members shall not be deemed to possess, my proposal, Mr. Chairman, would be that it reads dissociated members as defined in 1729-602 shall not be included for the purposes of calculating the majority of the members.
Okay, and Mr. Kaufman, at this point, that's a larger amendment that you need all of the conforming language that comes from your draft, I assume. You wouldn't want to just make that without all of the rest of the proposed changes to dissociated members. Is that right?
Yeah, Mr. Chairman.
Okay, so why don't you describe that as a conceptual amendment, refer to the language that we've got as alternative language, and then we'll look at it overall as one amendment.
Mr. Chairman, I second that.
Thank you, Senator.
Yeah.
So Mr. Chairman, then the idea is that we're just substituting the terminology of withdrawn members with dissociated members.
Excellent. Is there any discussion on that? We walked through this, committee. Anyone have any questions or discussion? All right, seeing none, we've got a motion and a second. All those in favor, please signify by raising your hand. Opposed? Motion carries unanimously. Thank you, Mr. Kaufman. All right, that began at the top of page 3. Are there any additional amendments on page 3?
Mr. Chairman.
My apologies. Yep, I see.
Has a
Thank you. Thank you, Representative Lindholm. Mr. Hopkinson.
Just for clarification, Mr. Chairman, so that amendment included changing the withdrawn members to disassociated throughout the bill. That was my understanding. I wanted to make sure that was correct.
That is correct. So with the proposed language that we see in the alternative draft for those circumstances.
Thank you.
Mr. Chairman, one clarification. I think we're talking throughout the bill with respect to the definition of majority of the members. There are a few sections regarding withdrawal. We want to leave those alone. But with respect to the concept of defining the majority of the members, we want to substitute dissociated for withdrawn.
Mr. Hopkinson, you following that? Okay, thank you. Representative Yin, did you have a question, or were you just trying to raise the fact that I wasn't paying attention?
Mr. Chairman, I actually wanted to bring up an amendment possibility for this page.
On page 3?
Yes.
Go ahead.
So, Mr. Chairman, I believe that there was some talk of a definition for Lao, and I remember that there was a good definition presented, but I did not write it down. If any member had written it down, I would love to support seconding an amendment for that language. So I don't have the language, so again, I'm not going to make the motion, but if someone has the language, I would love to second the motion.
All right. Do we have a motion with regard to adding a definition for Lao on page 3?
So
Senator
moved.
Nethercutt.
I moved, but I too did not write the definition now, recognizing that they had it. So I didn't take the effort to do that, recognizing we did have it exist. So if we can get that language that everyone consented to, I move to have that added in.
Mr. Chairman, I think I have that language handy, or at least the language that was referenced.
Mr. Kaufman, go ahead.
It was Lao means a decentralized autonomous organization under this supplement.
Okay. Senator Nethercutt, you comfortable with that? Shall we give staff flexibility?
Let's give staff flexibility to reach out to those stakeholders who provided that comment. I recall hearing something different, but I'm not objecting to Mr. Kaufman's language. I just want to make sure it's consistent with what those stakeholders cared about.
All right. Well, so the motion then, as I understand it, is to include a definition for Lao so that it appropriately reflects its purpose in the statute. All right. We've got a motion. We've got a second. All those in favor, raise your hand. All those opposed, raise your hand. All right. Motion is carried. Anything else on page 3? On to page 4. Motions on page 4. That was probably a motion on page 4. Motions on page 5. Page 6. Page 7. Lau and Dow, we're okay now with this. Anyone have any concerns? Seeing none. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Page 14. We've already had some amendments there. Page 15. Page 16. Page 17. Yep, Mr. Coppin. We can't hear you, Mr. Coppin.
Sorry, Mr. Chairman, on the last section 1731-115, the last sentence, Mr. Wright proposed some language. I can read it, Mr. Chairman, or if you'd rather me just provide that to.
Go ahead and read it. Go ahead and read it aloud real quick so the
So
folks listening will
the
know.
last sentence would read, where the underlying articles of organization and smart contract are in conflict, the smart contract will preempt any conflicting provisions of the articles of organization, except the articles of organization shall preempt any conflicting provisions in the smart contract as it relates to section 1731-104, 1731-106, A and B.
All right, we have that motion to amend. Is there a second? We have a second from Representative Lindholm. Any discussion? No discussion. All those in favor of the motion, raise your hand. Any opposed? Seeing none, motion carries unanimously. All right. Anything else on page 17? Mr. Hopkinson, go ahead.
Mr. Chairman, there wasn't discussion about this per se, but it is in the kind of changes that Mr. Wright had proposed. And I'm not moving or anything like that. I just want to make sure where there was a definition for digital asset that was not included in this bill draft. The committee may wish to consider whether or not to include a definition of digital asset, essentially just linking it to the statutory definition in 3429-101A1, which I actually believe will be amending, or the committee will be amending, and it's a separate bill here in the future. But the committee may wish to consider whether or not to add that definition to this draft.
Excellent. And on that, would we need that is stored on a computer readable format as long as we have as defined in? We don't need anything after that if we have as defined in, correct?
That's correct, Mr. Chairman. I think we just need to have it, digital assets means as defined in Wyoming statute.
Yeah. Anyone like to make that motion? Representative Lindholm, was that a motion? Okay.
Second.
Caitlin Long, was that a second? Thank you, Ms. Long. All right, we've got a motion and a second to include digital asset definition for the purposes of this statute. Is there any discussion? Seeing none, all those in favor, please show your hands. Those opposed? Motion carries. Thank you, Mr. Hopkinson. Good catch. Any further amendments? Any amendments on page 18? Seeing none, any further amendments at all? Seeing none, let's call the roll call on the bill, which is 21 also 263 working draft 5 as amended.
Senator Dockstetter.
Aye.
Senator Driscoll.
He's an aye.
Senator Nethercott.
Aye.
Representative Greer.
Aye.
Representative Lindholm.
Aye.
Representative Yin.
Aye.
Co-Chairman Olson.
We will hold the vote open for him and get his vote in a little bit.
Co-Chairman Rothfuss.
Aye. All right. Thanks, everyone, on that legislation. And we will continue to work as a working group. We'll continue to try and address the good suggestions that were raised today and improve the language. But we do have a bill as a select committee that we will sponsor if we need it. I anticipate we'll probably be able to work on it a little bit further. With that, we're a good bit behind, but that's okay. We've done some good work today. Let's take 5 minutes instead of 15 minutes if we can. Get back here at 11:15 following the break. Try and get back at 11:15 if we can. See you all then. Stop your video and mute your sound. Mr. Co-Chairman, we'll be starting back up in just a minute or two when folks join. We had a short break, and we'll get your vote when we get back into session. Folks, if you're out there, come on back. All right, just about have a quorum. There's Co-Chairman Olson. All right, Mr. Co-Chairman, welcome back. Let's get rolling. Mr. Co-Chairman, we did just have a vote, and we left the vote open on decentralized autonomous organizations. We had some proposed amendments, and committee has so far passed it unanimously. We'd offer you the opportunity to cast your vote on the legislation.
Excellent. I would vote aye.
Excellent. Thanks. Appreciate it. And hope everything's going well with your JAC work that you're also having to do at the same time.
Well, I can't promise that everyone's going to be happy with the budget. More likely, nobody's going to be happy. But maybe that's a win.
That would be my expectation. Yeah. Thank you, Mr. Co-Chairman. All right. And with that, let's get to our next topic on the agenda. Next topic is digital identity. And before we get started on that topic, I'll note that we do have lunch scheduled at noon, and we're going to break at noon. We won't conclude digital identity topic likely before noon, but I want to make sure that anybody who had anything scheduled between 12 and 1 can still hit those times. So with that in mind, we will work right up until 1 o'clock, and then we will have a hard stop, till noon. Then we'll have a hard stop until 1. We'll come back and we'll finish up on digital identity before moving on to the next agenda item. So if you've got anything planned at lunch, you should still be able to make that just fine. With that in mind, digital identity, we've had a good bit of progress through the working group. We have draft legislation that is before us, an updated draft for us to consider. And I think, let's see, I think we can get some preliminary comments if any of our team have any to make, but it might make the most sense to just get into the digital draft legislation first, after some short introductory comments of where we've been and what we've done. Daza, do you have any thoughts, or Christopher Allen, anyone who's been working on it? Welcome, Ms. Kaiser. Any thoughts before we actually take a look at the legislation, kind of on the process so far and what we've been thinking and working on? Go ahead, Daza.
Sure. Senator Rothfuss, thank you. My name is Daza Greenwood. I am a researcher at MIT, and I run civics.com, a consultancy. And thank you for the opportunity to talk a little bit about the process we've been following so far, which has included many of the people on this call. So after the last hearing on this matter, there were 2, I believe, drafting group meetings to take forward the recommendations and questions of the senators and representatives, and 1 or 2 subgroup meetings specifically to look at Christopher Allen's self-sovereign identity 10 principles, and to try to explore if any of those would be good candidates to translate to provisions in some of the statute sections that would apply the definition of personal digital identity. And so I'd say the results of that are in progress, and they've been very productive. And there has one sort of question/issue has arisen, which I assume we'll talk about when we get past this quick update and status overview. And it's this question of the word control. And this may sound familiar to the members of the select committee, because you especially been casting for some word to represent the relationship of a human to their digital identity. And we thought a word like control captured what we meant, but there may be legal implications to the word based on the remarks of Professor Carla Reyes, who came to one of our drafting meetings. I think she was concerned it might trigger areas of property law that are unintended. I'm not sure whether that's so or not, but at least your concern, at the very least, did cause us to take another hard look at that word, and we came up with other possible words. And I have a I think a happy contribution to make when we get into the substance of the measure. Based on some side conversations, we may just have had a eureka moment on the perfect word for that part of the law. And that concludes my overview.
Thank you, Mr. Greenwood. I appreciate the overview, and I'm looking forward to that super secret word. It's going to be great when we hear it, because I do remember that discussion, and we were struggling with a good word choice because of the UCC reliance on specific meaning to control, and we didn't want any ambiguity on that. With that, Mr. Allen, go ahead, and I see you too, Ms. Kaiser. Go ahead, Mr. Allen.
Yeah, so I wanted to thank you, Senator Rothfuss, for inviting us to this subcommittee to work on this. I think, again, to reiterate, after looking at a lot of laws around the world, there's a lot of stuff about personal data. There is, zero on digital identity, and yet, increasingly, as we're seeing in our own call here, our lives are increasingly online, and we need to allow our physical, unique identities to be able to have control over our manifestations in this virtual world. So we've got some really great experts, and we've had some great conversation from a variety of levels, and I really appreciate the time and diversity of opinions to put this all together, including international experts and such so this could be very influential, not just for Wyoming and the rest of the United States, but potentially the world. I like some of the more recent changes. I think the new word that's in this draft, I'm pleased with. We've been using the word control to avoid some of those property right things, but it may not have been far enough. But the fundamental thing is, you can't sell who you are, right? I mean, you can't say, that Caitlin now can be me if she wishes to be. I can't sell that. I'm still me no matter what. And that's both a responsibility, but also an authority. And, since that's at the root of real world identity, we basically need to be able to, bring that in and the rights and responsibilities into the digital world for that. So thank you much for the opportunity to make this possible.
Thank you, Mr. Allen. Ms. Kaiser, welcome. And please introduce yourself since it's your first time testifying today.
Wonderful. Thank you, Chairman and members of the committee, for having us. And thank you for everyone on the Digital Identity Working Group for being such a pleasure to work with. My name is Brittany Kaiser. I am trained as a human rights lawyer, but I work more as a policy expert in digital assets, blockchain, privacy, and data protection, both in the United States and globally. And so I have joined the Digital Identity Working Group and have been so impressed with the level of detail and debate that we have gotten in order to be in the position that we're at right now, with both a revolutionary piece of legislation as well as all of the different facets of it that we are considering. Even just yesterday, we got into a debate which has brought about, the better language that some of us have come up with. But the debate was really on how we can make sure that although our digital identity is made up of data points or made up of some of our digital assets, we're in Wyoming, our digital assets are intangible personal property, although we have not gone more specifically into personal data definitions just yet, although I'm sure we will in the coming year, that these digital assets, some of them have to have a higher elevated legal status than just property rights. And I, of course, for those of you that know me, am one of the world's biggest advocates for personal data as a property right. But because you cannot sell your digital identity just because in the same way that you cannot sell yourself as a natural person, you do not have the right to sell anyone into slavery because of human rights law. we need to think about that, given that digital identity specifically is meant to just be a representative of our natural person, which we have enshrined in this law. And that's one of the reasons why I find this piece of legislation to be so incredibly important. And it's especially important to protect people because of digital identity theft, and to think about how no one else will have the right to own the digital assets that make up your digital identity. And we've gone into the debate about, we still need to enshrine people with the right to have multiple digital identities that all relate back to a singular person, especially if you're using different digital identity platforms, or you are using your digital identity for different purposes and therefore would provide different data for different verifications. But it's so important that we make sure that that property right of those digital assets would not be able to be transferred, and therefore has a different legal status. And so that debate is where we've been trying to come up with better language so that digital identity is more akin to a human right as opposed to a property right. And we're trying to figure that one out. So I look forward to this discussion today. Thank you all.
Excellent. Thank you, Ms. Kaiser. Any questions for Ms. Kaiser or Mr. Greenwood? Or Mr. Allen for that matter? All right. Seeing none. Any further discussion from the working group? Mr. Marr, did you want to share a few thoughts?
Yes. My name is
go ahead,
Brendan
Mr.
Marr. Wonderful. I'd like to thank everybody for having me. The comments that I have are around this new word that Mr. Daza has proposed, or is going to propose. I kind of don't want to spill the beans here, but but I think it really gets towards the fact that we're dealing with something that goes beyond data, right? Data is really about that which is static, which pre-exists, but we're entering into a world where I believe more than 90% of all the data in the world will be generative, will be generated or generated in real time from algorithms. So what we need to put forth is something that captures both things that are static in terms of static and data, as well as the idea of information that is generated from algorithms and control over those algorithms. So this idea of control and how Daza will spill the beans and define this new word, I think really gets at the heart of how we can get at solving the problem of things that are static and things that are dynamic. And this is extraordinarily important going forward as we move increasingly into defining identity as it relates not only to data, but algorithms and transformations and processes. That's all I have to say for now. Thank you.
Thank you, Mr. Marr. All right. Any other comments? Any questions for Mr. Marr? All right. Seeing none. And thanks to the whole digital identity work group, Claire Sullivan was also instrumental, and Scott David. We've had an incredible team that have worked together, and Professor Reyes. We've had a lot of discussion, a lot of opportunity to really work through a relatively short number of pages, but trying to get this definition right, since it really will be a first of its kind definition that others are likely to build off of. Professor Reyes, yep, I see you there. Go ahead.
Hi, so I don't think I introduced myself before. I'm Carla Reyes I'm an assistant law professor at SMU Dedman School of Law. Thank you, Mr. Chairman, for calling on me. I have a persistent question. I don't really know for who it is, like which of the members who have just spoken it's best directed to. But my persistent question, I've been mulling this over for the last week or so since the last meeting, is about the definitions themselves. So particularly in light of Mr. Mayor's recent comments about static versus dynamic data, et cetera, I'm having a hard time distinguishing between the two definitions, personal digital identity and organizational digital identity, and like the normal definition of personally identifiable data in a lot of other statutes. So as I read those definitions, it could literally be referencing any piece of my data that relates to me as a natural person, by, for, what's the word? Of, by, and for me, rather than like the whole me. And maybe that's the point. But then if that's true, I don't understand how I act through that as a natural person in the other provisions of the act. And so for me, it's really a definitional question. It also, because if that is true, if you really do mean it could be anything like my electronic signature, then the more basic question for me is, how is this different from UEDA? And so those are my persistent general definitional questions.
Well, thank you, Professor. And let's get into the bill draft and explore that a little bit, explore the discussion. And I think those concerns will be a little more clear as we do that. So I'm pulling up the draft that we have before us. One second while I get it in front of me. So we're looking at 21 LSO 216 working draft 0.6. And this is very similar to what you saw before in structure at our last meeting, but there was a lot of discussion and a lot more working group activity on the definitions. So I'll just walk through the legislation real quick. We're creating a new act as Chapter 30 in Title 40, which is going to be called the Digital Identity Act. You see that we start with definitions, and there were two drafts that we had before Select Committee. One of them was working entirely in this part of statute. The other one was looking at some amendments to Title 8, and we're basically doing a little of both in this one to make sure that we have some clarity. You'll see that our definitions section is bare bones, and it's going to refer to a new definition of personal digital identity, which Professor Reyes was referring to, as defined in 81102A, Romanet 18, and organizational digital identity defined in the same area, Romanet 19. And you'll see that we'll reference or we'll define those below. We're creating a new section here, Acts through Digital Identity, that is consistent with the provisions already in Wyoming statute regarding actions by an individual and electronic actions taken by an individual that basically instantiates the personal digital identity with certain rights, so to speak, so that the personal digital identity and organizational digital identity can take these actions consistent with other actions that an individual can take through electronic signatures, etc. And then the kind of key provision here that you'll see on page 3 going on to page 4 are the new definitions that we're adding back in Title 8, which are general definitions that would then apply throughout all of statute. And where we were at prior to this last working group meeting that I couldn't attend, which had a discussion over a concept we didn't quite reach on control, is that personal digital identity means the intangible digital representation of, by, and for a natural person over which he has autonomy and through which he intentionally communicates or acts. So the discussion that we've been struggling with is we wanted to put a concept of control in there, and part of that is what would address Professor Reyes' concerns of kind of what that means. How do we actually affect this personal digital identity? But we didn't achieve it. We couldn't use control because we were concerned about how that related to the UCC. We were uncomfortable with that. And so I'll hand it over to Daz in a second to talk through what the working group came up with as a proposed alternative. And then organizational digital identity is parallel language that we can provide different rights and protections for, but we wanted to make sure that it was separated out. And you see that the language is parallel for a corporation, business trust, estate trust, partnership, limited liability, etc. Joint venture, you can read the rest there, through which they intentionally act or communicate. So parallel language and then the effective date. So before we go on and talk about some of the proposed changes, let me open it up to the committee members to see if there are any questions on the bill draft as it's before us and the discussions that we've had before we get into this concept of control. Any questions? Senator Nethercott, go ahead.
Mr. Chairman, not exactly a question on the bill draft, but I did hear Mr. Marr promise that Mr. Greenwood had some beans to spill.
He does that. Yep. Are you
Okay.
ready for that? Are
This
you
is
ready
all
for that,
built up.
Senator?
I'm ready for the beans.
All right. Well, let's jump right to that then. Mr. Greenwood, so how are we going to address this concern that Professor Reyes has about control and getting the language right?
Thank you, Chairman Rothfuss and Senator Nethercott. If Boston is known for anything, it's Beantown. And so, so firstly, let me just say that the question that Professor Carla Reyes raised about about potentially the definition of control or the word control raising property law constructs that we didn't intend, I think got us back to what the essence of the idea was initially. And I hope that this also speaks somewhat to Professor Reyes', I think, completely reasonable query. What is this law about? Like, what does it do? Is it a signature? Is it PII? Is it something else? So the original purpose, which we think is better served by other words, is to provide a legislative definition and a building block for that type of identity in digital environments, let us say, that sources from a person and is not assigned to the person, such as, say, like a Google account or an employee account that one can act through or communicate through. So it's that level of functionality that it's that zone that we're trying to get at. And personal identifiable information is, involved with and attached to, generated from these types of identities for sure, but it's not the same as person identifiable information. It's more like the representation of the person themselves, like maybe like an avatar, very roughly in VR or something like that. Or, I mean, for me in my career in IT, it would be something really close to an account. Like if I spun up a Unix box or created a Active Directories, directory system, I'd create accounts for people. But all those accounts operate within usually a hierarchical structure where someone else is in charge. Is that really the right one for us to act on our own behalf when isn't there something missing, I guess is the question here. And there are technologies, especially public-private key pairs, where one can generate one's own keys, can have an open source wallet, and there's other mechanisms as well, using other types of account systems and authentication and similar functions where one could create their own server or it could be provided to them. But what about the legal overlay where it's one's own identity? So we come to self-sovereign identity, which I think was really the immediate trigger for this line of inquiry. And the word that we had been using initially was it's a self-sovereign identity. That has its own kind of bag of worms, as it were, and potentially unintended consequences, and it may or may not be the right word. So fast forward a little bit, we had a bunch of words. Maybe it's people have power over it. Maybe they have authority over it. We had a few words that we picked up after Professor Reyes' question, and we came up. And you'll see in the current draft the word autonomy, because we thought that was closest at that time. Beans have not yet been spilled, incidentally, just a little spoiler. And one of the issues, so autonomy is a pretty good word for this type of, I think Senator Nethercott and others have expressed that what we're looking for here is something more like natural law, Representative Lindholm, and a space that articulates the kind of rights of people to consent to be governed, for example, human rights law that Elizabeth Ramirez talks about, for example. And autonomy is pretty close. I'm not sure that's the right part of speech. Has autonomy over? I've never heard that phrase, and I'm not a grammarian, but I think it might actually break the word. to say you have autonomy over something. I don't know, but autonomy is getting the right direction. Well, Brendan and I were just chatting last night, mostly about family and so forth, but we did talk about digital identity. And in talking it through, the word that popped into my head was dominion. And it's an old styley kind of word, but Brendan, to his credit, as usual, asked the right question. He said, well, what's the definition? And I thought I sort of knew it, but that made me Google it. Here's what I found. According to Merriam-Webster, the definition is, under law, supreme authority or sovereignty. And the next definition is absolute ownership. So it has a connotation of that, but it's not the legal term ownership. Oxford Languages definition comes right out of the gate. Definition 1, sovereignty or control. Kind of a bullseye, but without using the words sovereignty that raises serious questions, especially with not insurrection. Like there's secession talk. There's all sorts of like third rails that are arising right now with respect to sovereignty. I'm just saying, and control maybe has other issues. Here's a word that's the definition of them is sovereignty or control, but it's neither of those words. So I just want to throw on the table the possibility of replacing has in the current draft has autonomy over with has dominion over, and otherwise letting the definition ride. May I make one other comment, Senator Rothfuss?
Yep, go ahead, Deza.
Thank you. Carla, Professor Reyes rather also raised like two critical questions that really got me thinking. One of them is like, well, what can you do with it? And and where would you use it in law? And these questions, of course, have come up in previous hearings and in drafting group sessions, but have they really been dealt with adequately? Perhaps not. So we have identified rules of attribution as one thing one might be able to do under just standard UEDA with through one's own identity, and that's, I think, almost goes without saying, but it's legit. It doesn't break anything, and it's perhaps helpful. I just want to throw on the table one other possible thing, where the select committee has ultimate say, and it's over the state government itself. And when I was a state government lawyer, something we would sometimes do when we were seeking to promote economic development, but we didn't necessarily want to put like money in, and we didn't want to be interventionist in the economy, but we wanted to signal and maybe incentivize, was we would authorize state agencies to accept certain things. They'd still have to go through procurement and set rules and so forth, but it would be a nice signal. What if another thing, in addition to don't replace, but add to the rules of attribution, some statement along the lines of state agencies may accept a person's personal digital identity as a means to log in to their systems, as a means to make requests for public records, as a means to receive notice, or things like that. I was just kind of scanning through the regulations and the statutes in Wyoming law to see the sorts of things people do in their own capacity, not solely on behalf of a business or in some other capacity. And there's actually quite a few things, I think, but if that's a direction the committee thought might be interesting to go, perhaps the working group can do a more careful review and perhaps find candidates. One addenda to that thought I was thinking is, one might want to put some boundaries around that, that almost go without saying, but maybe don't, which is, applying standard procurement, doing an appropriate risk analysis, maybe making sure that there's at least one market alternative that also provides the type of functionality. If I was in a legislature, I would probably say making sure there's at least one open source alternative so that people can pivot without becoming captured by a vendor. But at any rate, the basic idea I wanted to add was the possibility of signaling that state agencies may choose to accept a citizen or a person's personal digital identity as when conducting interactions or transactions with that person. That concludes my comments. Thank you.
Thank you, Mr. Greenwood. Following up briefly on those points, and getting at what properties this digital identity or organizational digital identity will be imbued or empowered with, what does it do? That's something that we've discussed, including and expanding upon in what would be a section 103, I guess, is where it would be. So 4030 103 or elsewhere. In other words, that's the kind of thing that we can build off of, whether that's similar to California privacy statutes or the EU, or determining that your digital identity is yours, which aspects of it are property, which aspects of it are intrinsic to the individual. But we kind of have to have the foundation. And the way we were trying to structure this was to come up with a foundation that we can then have strong definitions and build from. And that's actually the opposite of what everyone else has done. And I think we probably understand why now, because it turns out it was really hard to define these terms, and we're still working on it. So it's pretty clear why other states just dodged and provided some rights without getting to the core of what a digital identity meant, which is why this is relatively formative in its in having an attempt and putting forward definitions about digital identity that we would expect others to potentially emulate. So I wanted to point that out, and I do like the concept of dominion over. I think that's a good way to go about it. It sounds good. We'll have to visit with staff and see if there's anywhere else in statute that gets at dominion, but I like it. So we'll see. It was a good one. With that, let me go to Mr. Allen and then Professor Reyes. Mr. Allen, go ahead.
Thank you. Again, Christopher Allen, Blockchain Commons. So I think one of the key things to answer Dr. Ray's question or whatever is that, this is not, the purpose of this definition is to define the decision maker, okay? It's basically saying there are certain things that we can represent online that are of the agent in a computational sense that gets to make decisions. And this is a very important part of natural law and other stuff, in the sense that the as natural persons we get to form a union that caused the United States and caused Wyoming, et cetera. We got to make the decisions collectively, and individually we get to make decisions about certain types of things. And we needed to be able to describe that in a way that also applied to decisions that we make online and virtually and such, so that we can say things like, this digital data was not proper, the decisions were not made properly about its presence on a particular system or its use in a particular algorithm, whatever, because at its fundamental level, the decisions about how that data was made available or whatever was not properly authorized by the proper party. And that's that proper party, we've got to make, we've got to, connect some dots between this definition and digital data and all that kind of stuff. But it's really about the representations of our decision ability. So that's why we have this sort of self-sovereign originally, and then we kind of went to control, which is also about decision making, and then we went to autonomy and now dominion. What we're saying is there are some things that are ultimately a person's decision and can't be compelled from them without court orders and law and other different types of things. It's their choice. I can leave this call. I can join in various calls with permission from others, et cetera. Where are those lines? So I do like that we've got a good fundamental start here, but I do agree with you, Dr. Reyes, that now we need to connect the dots to things like the California legislation, which does not define personal identity at all. And when it does define personal data, it doesn't do it in a way that really defines who really has the authority over it. I think they kind of say, well, the state has a responsibility to allow lawyers to pursue abuse of it, but that's kind of maybe the wrong angle here. So anyhow, I like where we're going. There's still a lot of work to do with connecting the dots, but even if in this session we kind of agree this is a great baseline and just got this in, I think it's then useful to build a lot of stuff over the next couple of years on. So thank you.
Yep, thank you, Mr. Allen. And let's go to questions first before going to Professor Reyes. Senator Nethercott, did you have a question? And whether it's for Mr. Allen or Mr. Greenwood, I forgot to ask for questions. No. Any committee member have any questions for Mr. Allen or Mr. Greenwood? Yeah, go ahead, Senator Dockstader.
Well, actually, both of them, Mr. Allen. Where do you see this going then in 2 years? A little more specifics. Just let's put some goals down here.
Sounds good.
Sure. To follow Daz's thing, I think there are a lot of bills currently under consideration, as well as bills coming where we haven't been very clear about the nature of was proper authority given by the person to do X. We have a SIM bill coming up with Caitlin and other people. Was the authority to transfer this phone number done by a person? We have in the Dow discussion, there was a lot of discussion about how does these changes happen in how a group of people join and participate in a digital to create a digital authority, a group authority, which is the second half of this definition, which is the organizational digital identity that parallels. They're basically taking their personal digital identity along with support from the state, basically saying, well, for these matters, I am giving my authority to over these assets and these decisions to follow this thing. So I feel like there's a lot of dots there. I think there's some other dots in the area of, you've got driver's licenses, you've got other different types of things that are, allow individuals to signal their preferences, whether or not it's a vote or to do different types of things. And they all do not refer to people's, digital ability to do things. They only refer, driver's license gives you as a person in the real world the right to drive. But that's a little bit different when we're trying to drive in the virtual world. So, for these things, we need to say who has control and where's the line where it becomes property. I can clearly license to you a book. I can do all that type of stuff, but other kinds of intellectual things, if not properly licensed, are theft under property law. But then there's some things that aren't even property law. They're just like a fundamental right. Like I should have a right to be able to petition my legislators. I think that's enshrined in law in some place. We just need to be able to do all of these things we can do in the real world, and all the dignity we have as people in the real world should be also reflected online. I hope that helps, Senator Dockstader.
Thanks. And that brings us right up to noon. So Professor Reyes, can we start right after lunch with your question?
Yeah, it'll give me a minute to put them together, because
you can make those questions perfect. You'll have a full hour to really to get those polished up. All right, excellent. Thank you, Professor Reyes. I appreciate that.
Thanks.
All right, and with that, it is noon. Let's break for lunch. We'll come back and we'll pick right back up where we left off with Professor Reyes and look at more about digital identity, and then get to the point where we take some public testimony and then work the bill and contemplate some of the language that we've been discussing. Any final comments or questions before we break for lunch, committee? All right, seeing none, let's be back here right at 1 o'clock. See you all then. Thank you.
1 Mountain Time.
1 o'clock Mountain Time. That's correct.
Thanks.
Be sure to mute and stop your video.